Good afternoon, everyone. My name is Tony Varona, and I have the honor of serving as the Dean of the University of Miami School of Law. First of all, thank you to all of you who have worked tirelessly to put on this remarkable event. In particular, I'm very grateful to my old friend and dear colleague, Professor Lisa Iglesias, who spearheaded the creation of this very important gathering. Thanks also to our symposium partners, the Association of American Law Schools and the Miami Law Race and Social Justice Law Review, and our symposium co-hosts, the American Society of International Law, the Blacks of the American Society of International Law, BASIL, the Hispanic National Bar Association, HNBA, the University of Miami School of Law American Constitution Society, the Cuban American Association, the Cuban American Bar Association, the Health Law Association, the Human Rights Clinic, and the Society of Bar and Gavel. I am delighted and honored that we are joined today by our distinguished keynote speaker, Professor Gerald Torres, who is a past president of the AALS and currently serves as a professor of environmental justice at the Yale School of the Environment and a professor of law at Yale Law School. Professor Torres, we are delighted that you are here with us today. My sincerest gratitude and appreciation to you and to our all-star lineup of exemplary panelists and student moderators for joining us. This pandemic has impacted deeply our nation and indeed our entire world. The way we do everyday activities like shop for groceries, eat at restaurants, communicate with coworkers, send our children to school, or gather in public for conferences and symposia like this one, has shifted in ways that would have been unimaginable only a few months ago. The urgency of this moment is clear. Although we have all been impacted by the virus, we have not all been impacted equally. The disproportionate effects of the virus have major implications for many aspects of our society and our lives, including civil and human rights, public health, financial stability, poverty, privacy, criminal justice, and immigration, among many others. At the same time, America is living through a moment of reckoning, long overdue, sparked by the killing of George Floyd and other Black people at the hands of police and the Black Lives Matter protests that rippled across the country thereafter. What also is clear is that although the virus itself is colorblind, its effects have not been. As a nation, these events have led us to grapple with acknowledging and addressing issues like systemic racism and inequality that have plagued our nation for generations and that become all the more recalcitrant in the midst of crises like this one. These circumstances also have been a call to action for lawyers and legal educators across the country to take a stand in responding to legal challenges that have arisen in the aftermath of the pandemic. Today, you will have the opportunity to hear nationally and internationally renowned legal experts discuss some of the legal implications around civil rights that were brought on by COVID-19. Specifically, this symposium will address a few of the many civil rights issues exacerbated by the pandemic and provide a forum for discussion on several key topics. First, what implications do the civil rights challenges we face in this country have for our international institutions, such as international courts, UN special rapporteurs, and the inter-American system? What role do these institutions have in safeguarding human rights and protecting against discriminatory police practices, excessive use of force, crimes of negligence, domestic violence, terrorism, and states of siege? Second, how have seemingly neutral policies and practices enacted during the pandemic, such as stay-at-home orders, been used to target, detain, or incarcerate communities of color and other vulnerable populations? Third, how has the pandemic exacerbated civil rights issues arising from unequal treatment to employment, housing, education, and access to justice. How do these issues intersect with race, disability, age, gender, class, and occupations deemed essential? Lastly, how has the pandemic exacerbated disparities in treatment in our immigration system? Specifically, how has discrimination in citizenship status limited access to much needed federal relief and health benefits, or led to the exclusion of immigrants through detention and mass deportation? I am very much looking forward to hearing from our keynote speaker, our many distinguished panelists, and our student moderators who will help frame and participate in our discussion today. Thank you all again for joining us for this very important conversation on the implications of COVID-19 on civil rights. I now will turn the virtual podium over to my colleague and friend, Professor Lisa Iglesias. Professor Iglesias is a professor of law at the University of Miami School of Law and the chair of both the Civil Rights section of the Association of American Law Schools and the chair of the Constitutional Law section of the Hispanic National Bar Association. Lisa is a civil rights and equality law trailblazer and pioneer who co-founded LatCrit, which for decades has cultivated connections among and scholarly and pedagogical innovations among Latinx and allied legal academics here in the US and around the globe. Professor Iglesias, thank you, and the virtual podium is now yours.
Thank you, Dean Varona, for opening this important conference and for the leadership you have brought to the University of Miami School of Law and the good example of professionalism and collegiality that you set for our community on a daily basis. I want to thank everyone for joining us. I want to thank the student members of the University of Miami's Race and Social Justice Law Review who are acting as moderators for our panels today. And I want to thank in particular the members of the Working Group on Promoting and Defending Civil Rights in a Time of Coronavirus for responding to my call back in March as chair of the Civil Rights section to take up the serious civil rights issues posed by the pandemic and by state action and inaction in response to it. I look forward to hearing all you have to say today. Today, I have the unique honor of introducing an inspirational, intellectual, and visionary leader in law and social justice, Gerald Torres. Before I tell you things you may already know about Gerald, I want to tell you something you may not. Gerald is, in his heart of heart, a poet. He grew up, in his own words, in the real California, which he affectionately calls the malignant heart of growth, in San Bernardino, the Inland Empire. Notwithstanding his California roots, as a professor at the University of Texas, Professor Torres worked tirelessly to open doors for high schoolers to go to college in the Texas university system. He is the first Latino professor of the association, president of the Association of American Law Schools. His courage, work and work ethic, profound humanity, and example have made it possible for those who follow in the legal academy to achieve in his footsteps. Gerald Torres is currently professor of environmental justice at Yale School of Environment and a professor of law at the law school. Among today's many influencers, Professor Torres is the original. Contemporary environmental law reform work has benefited enormously from the leadership and guidance of Professor Torres. His work has examined how US regulations have created racially or ethnically marginalized communities that bear a disproportionate share of environmental burdens, and also has focused on developing strategies to address these injustices. He is a leading scholar of critical race theory and a longtime friend and supporter of the original Latina and Latino Critical Legal Theory, Inc., also known as LatCrit. As the co-founder of LatCrit, I have inestimable appreciation for Gerald's relentlessly courageous work in advancing the project of developing theoretical frameworks that examine questions of race and racism from a legal standpoint. Gerald's book, The Miner's Canary, Enlisting Race, Resisting Power, and Transforming Democracy, co-authored with Elanny Lago, is in fact one of the most provocative and challenging books on race. He has spent his career examining the important connections between social justice and environment, agricultural, and food systems. And his research into how race and ethnicity impact environmental policy has been peerless in its influence on the emergence and evolution of the field of environmental justice. Not just what he sometimes playfully refers to as an academic egghead, Gerald also served as Deputy Assistant Attorney General for the Environment and National Resources Division of the U.S. Department of Justice during the Clinton administration. I am so pleased, so delighted to have Professor Gerald Torres with us today and very much look forward to his keynote. And with that, I turn the virtual podium over to Professor Torres.
Well, thank you, both Dean Varona and Professor Iglesias, I can call you Lisa, I hope, for those really generous introductions. You know, it all has to do with just basic, everybody knows it has to do with just doing the work, right? There's, for all of us who are concerned about social justice, the work unfolds in front of us every day. And the task that we are faced with is choosing where we're going to put our energy at that moment. So thank you for that generous introduction. Okay, I'm going to talk briefly about what has emerged as not just the COVID pandemic, but really a form of governance under what have become chronic emergencies. So that whether we go back to the original crisis that was self-created by our government at the border, and I don't want anyone ever to forget for a moment, and it's hard to forget when you read the headlines about the doctors in Georgia who were, performing needless hysterectomies on immigrant women, but the violation of human rights that continue even as we sit here at the border, the dehumanization of immigrants, and the treatment of Latinos in particular, the Latinx community in particular, as somehow not full members of the American community. So the emergencies, the compounding chronic emergencies is actually a form of governance. And so I want to talk about that, and I'll spend some time talking about COVID-19 and how that the emergencies that have revealed themselves rather than being created by the pandemic, in fact, challenge fundamental governing norms. Now, when you go back over the last 3 years, one of the things that's important to recognize is that there's been an action and then pushback. And so there's been a kind of vacillating response as the current administration has attempted to put forward an agenda that by some measures was outside the boundaries of what a conventional discourse, but also outside the boundaries of what were conceived to be conventional civil rights and civil liberties limitations. So beginning with the immigration crisis, and the immigration crisis was, of course, called an immigration crisis, even though there was very little actual factual basis for it. In fact, if you understand it essentially, initially, as an anti-Mexican initiative, the reality is that the economic situation in North America as a whole had in fact reduced the flow. The immigrants from Central America were fleeing the collapse of civil order in their countries. That is also largely tied to the way in which we as a nation responded to gang violence domestically and incorporated it into the repatriation of people who had been found to be involved in gang violence back to Honduras and El Salvador, and creating or exporting the foundations of disorder in those countries, creating a humanitarian crisis that we treat, or our administration anyway, has treated as effectively an invasion. The creation of the wall, or the attempted creation of the wall, is of course somewhat ironic, given COVID-19, since we find ourselves, in fact, unable to leave the country, largely because of the failure to manage the infection of the COVID-19 virus. So let's go back. In some ways, we can trace the idea that you govern in a time of exception back to 9/11, whose anniversary we just observed. Now, one of the things that I would actually encourage all of us to do, especially in a conference about defending civil rights and civil liberties, is to remind our students and remind ourselves that the baseline for what were conceived to be generally available civil liberties changed dramatically with 9/11. So there is actually a bright line of before and after. And what 9/11 did is it created the idea that in some situations, the things that we took to be normal governing norms were no longer valid. So that's the background framework. Even before the COVID-19, we saw that technique of governance in full force. Now, what is it? The theorists Carl Schmitt and Agamben have argued, and Agamben in particular in a book called The State of Exception, has argued that the real state, that is the real state, not the state that we identify or point to or use our other legal techniques to outline and suggest limits to, but the real state. The real state, that is the locus of power, can be found in those persons or those institutions that have the capacity to continue to govern beyond the limits of law because we find ourselves in a state of exception. That is, you see this casually referred to as people welcoming an emergency. Because when you welcome an emergency, the justification for a particular action is the emergency, and the reassurance is that because it's an emergency, it's not likely to happen again. So that the extraordinary power that is exercised as an expression of an exception to the general rule, an exception to the general ways in which normal governance occurs. The problem, of course, and the problem that we're dealing with now, is who gets to declare the emergency, who gets to declare when the emergency is over, and who gets to declare when those powers that were exercised in order to address the emergency are at an end. That is, when we will revert to what we would all consider the normal set of limits that our government functions under. So if you agree with me up to this point, you then recognize that the category of acceptable governmental norms was dramatically transformed with 9/11. There was a robust civil liberties bar that pushed back against efforts to expand the network of emergency powers, although we still labor under them. But the idea that there was a government that would respond to pushback and would respect courts when the courts articulated limits to the use of executive power in particular was deemed to be one of the fundamental norms that still maintained our capacity to have faith in the rule of law and its ability to cabin governance. That is, to make sure that government itself is an expression of law, not an exception to the law. So you then have the manufactured immigration crisis that I've already talked about. And then you have the uprisings in a response to the killing of George Floyd. But of course, it wasn't just the killing of George Floyd. It was George Floyd's death was emblematic of the way in which certain members of our population, particularly Black people, but also Latinx people, but particularly Black people, were deemed to be governed by a different set of rules. And it's the challenge to those different set of rules that led to the resistance. And one of the things that's important to note is the resistance, while it was led, and we can trace this back obviously to Ferguson or even before, while it was led by African Americans, by Black people, it was not confined to resistance arising from the Black community, but in fact was generated widespread cross-racial support and allyship. We saw this as well in the DAPL pipeline resistance, the Dakota Access Pipeline resistance. There you had Native people leading the resistance, but it wasn't just Native people. It was Native people who had allies from the full range of the American population that led that resistance. So the response to the civic unrest that was produced by resistance to the what appears to be kind of almost indiscriminate killing of Black people. And I don't know about you, but as I turn on the news, you know, I found myself just saying to my daughter, right, you know, can we just stop? Right? Can we just stop killing Black people? That expression, which was a casual expression to my daughters who were watching the news, really, for me, captured the exasperation with which the killings went on, and it required public resistance to make the government respond as if this were outside the norm. But, and here we get back to the main point, which is the idea of governing in a time of exception. The civic unrest, of course, produced an additional justification from the administration for treating the resistance as if it weren't part of the normal and accepted response of a people against what they felt was the overreaching and oppressive actions of their government, right? And, you know, it's important to remember history here, right? The idea of resisting government overreaching is a time-honored, or government oppression is time-honored, that dates back to the time of the founding of the republic, right? We celebrate the Boston Tea Party, which, you know, might be categorized as the lawless looting and destruction of private property. But it, of course, isn't conceived of that way. It's conceived of as legitimate resistance to the oppressive actions of King George. We also might recall that the statues to the king were actually pulled down at the same time. And so the idea that the removal of Confederate statues and other monuments to treason is somehow a new phenomenon. It's not a new phenomenon at all. It's part of the history of our resistance in the United States. Nonetheless, if you follow the news, you see a couple of things. One is, you said the federal troops were sent in, even though the state asked that they not be sent in. And the Attorney General is currently considering the charges of sedition against the people who are protesting the killing of Black people at the hands of police. So I want you to think about that for just a moment, right? So the idea that you can convert something that is traditional in the history of American resistance to government actions, from protected First Amendment activity to seditious activity, is a critical step. Because what it reflects, and remember, we're here talking about this in the context of what I adopted from Agamben to call the state of exception. What it reflects is a transformation of governing norms. Now I'll finish up by focusing on COVID-19, since that's the topic of the conference. So how does COVID-19 figure into this? Well, in many ways. First of all, COVID-19 reveals, but it did not create, the inequalities that we see. COVID-19 functioned like some stagehand pulling back the curtain and revealing the inequities and the willingness of the state to sacrifice some of its people to satisfy a policy that it thinks is necessary. And here I refer you to the things that were revealed just recently, that the executive order declaring meatpacking workers essential workers was in fact drafted by the meatpacking industry representatives themselves. That disregard for the health and welfare of citizens, non-citizens, people who are subject to the jurisdiction of the United States violates a fundamental obligation of governance. The idea that the COVID-19 virus is going to be treated as if it's not serious in order to attempt to achieve something like herd immunity means that there's a willingness of the state, of the government, to sacrifice, if the numbers remain what they are, right? Close to 6 million people. Now, I take it personally, and perhaps I shouldn't, right? But I've had 3 family members contract COVID. They live in states that were where they were ordered to go back to work. We learned from documents that were revealed that the government response to COVID was based initially on the presumption that the states that would be hardest hit would in fact be blue states. And so the people who run blue states would suffer the political consequences of the deaths and the illnesses that they suffered. That's a level of cynicism that I like to believe is unprecedented, although I'm sure I sound like little Bo Peep to most of you. But it's a kind of cynicism that is so extreme that you have to try to make sense of it. And the sense I've been trying to make of it in the talk today is the idea that if there is an emergency, and what I've been describing is a state of chronic emergencies, right? If there is a state of emergency, then the rules for managing civil life and civic life can be transformed. And they can be transformed against the background of the calamity that you are attempting to reduce the severity of, or they can be transformed by suggesting that the obligations of government are different. One of the fundamental obligations of government, and the thing upon which the legitimacy of government lies, is that it exists primarily to do things which we ourselves cannot do for ourselves. So it solves public action problems. It is able to mobilize resources that the public or private individuals in members of the public or the private sector cannot do themselves. And it moves resources in order to ensure that we will be not made worse by the actions of the government. So one way to assess the response to the ongoing cascade of crises, and then in this case, the COVID-19, is to ask, has it been made worse by the actions of the government? And if it has, how has it been made worse? And what are the remedies to the actions that have produced the worsening of the problems? That's the challenge that this conference is going to face. I suspect over the course of the day, we will hear a lot of criticism. I hope we hear as well proposed solutions. I hope that it's done not just in the context of the disease that we're facing, but that it's done in the context of challenging the idea that the state of chronic emergency that we're in and have found ourselves in fact, reshuffles the deck or sets a new baseline for acceptable governmental behavior, or gives us an excuse for not recognizing the ways in which the rules of law and the rule of law is designed not just to control or police the people, of course, who stand behind the legitimacy of those laws, but in fact to control the people who run the government. And can reconfirm that we are a government of laws, because I think that's actually at stake. And what COVID-19 has done is it's revealed that challenge, even as it's revealed the inequality that we all knew was there, in the way that the resistance spawned by the killing of George Floyd revealed the chronic difficulties with law enforcement, the continued cheapening of Black lives and brown lives, the attempt to disincorporate some people who've been here forever from the life of the nation, and the capacity to call on the nation to act in all of our names. Those are the crises we're facing. COVID-19 merely revealed them, but they didn't create them. I hope that you have a great conference today. I've got to go teach a class, so I'm going to leave not long after, but I'll come back. Thank you very much. Back to you, Lisa.
Thank you, Gerald. Thank you very much. And I guess this is the time where we engage in the question and answer and invite questions from the audience. If anybody has any observations or comments or questions for our keynote speaker, now would be the time. You can type them into the question and answer. I will start us off by saying I wonder about whether or not we can accomplish some of the things that you're asking us to do if we start with the theoretical frameworks provided by Schmidt and Agamben. In other words, that is a political theology and at a theoretical level. And the question really is, how do you reconcile those frameworks and use those frameworks in the context of our constitutional form of government? Because it's just a flat statement saying that there's an alternative government to our constitutional government. And yet the effort to operate that machinery involves looking at the way it's collapsed or failed to produce the results. And one of them is that the Congress simply doesn't claim its power. And so it has the power to reverse the authorization for the use of military force that has us in a state of emergency, and yet it doesn't. So there's a politics there, and there's an economics to that politics that I wonder how you think that that logic and that reality can be reconciled or dealt with when we approach it through the lens of the theoretical frameworks that you're presenting. And so I've just started out that way.
I mean, the question you asked is exactly the right question, right? Because one of the things that's been talked about at length, and one of the things that we have to engage both as scholars, but then have to reflect on how we would engage as practitioners, right, is the idea of the unitary executive, right? Every government, even the one that I was in, right, they take you aside and they say, look, we believe in the theory of the unitary executive. Well, maybe what we need to do is to ask whether that theory is in fact, one, consistent with the separation of powers that the Constitution outlines, or two, consistent with a desire to protect, right, the people on whose behalf the unitary executive might be called on to act. So I think we need to challenge the idea that we are things are so chronically destabilized that the ordinary rules don't apply. Remember, Lincoln suspended habeas corpus in the Civil War, right? We're not there yet, right? We're not there yet. And so what we have to maintain and insist on is that the normal operation of law ought to be the baseline. That there isn't a justification for suspending what we think of as the normal operation of the rule of law. That's the first thing. Now, so that means, it means challenging things like FISA courts. I mean, it's a deeper problem. That's why I started with 9/11, right? Because it's a problem that when we were all deeply threatened, and I'm including all of us in this, when we were all deeply threatened, we were willing to let stuff go. And what we weren't prepared for was the way in which those actions during the moment of an emergency would be naturalized into the system of the way government functions. And we've got to resist that. We've got to resist the naturalization of those, quote, emergency procedures into the way government works, because the impact is to disable us, right? And the answer is no. The answer is no. And we've got to insist on no.
Okay, and a follow-up question to that, and then I'll turn to the questions there's a question from Professor Davis. Do you think, based on what we've been seeing since the pandemic, that the mechanism of resistance that's most effective is going to be one grounded on the formulation of legal arguments and the invocation of legal process, or in the streets?
Both. You know, as you know, my work over the last 10 years, although I should say my limited work over the last 10 years, since I haven't produced as much as I should, has been focusing on the role of social movements in the production of legal change. You know, there's no necessary political valence to that, right? So it can be right-wing political change or left-wing political change, right? So no, but the actions in the street have to be understood as statements about what acceptable law is, right? That's what their statement's about. So that it is going to be required. Lawyers are going to have to make arguments. There's no question. But there has to be mobilization to resist, and I just think it's necessary. You know, a long time ago, God, 20 years ago. I hate being this old. 20 years ago, we commissioned a book written by Penda Hare, who is doing weapons grade voting rights work in North Carolina. I mean, she's fabulous. A book called Louder Than Words. And what we did is we wanted to go around to see what kind of resistance was happening around the country, but that was basically under the radar. And in fact, there's a lot of resistance. And we need to valorize that resistance and insist that it's not sedition, it's in fact patriotism.
Okay, excellent. We have some questions. One from Professor Davis. You have been at this a long time. Are you still hopeful? And if so, how do you keep that hope alive?
Yeah, I'm hopeful. I'm hopeful. I'm hopeful because while I've spent a lot of time in the academy, I spend a lot of my time with people who are actually organizing and resisting. Right, so I've been working with people in LA on anti-police violence stuff and also anti-gang work. I've worked with people doing voting rights stuff. Advancement Project did, and you're down in Florida where the battle, you know, has been joined on felon reenfranchisement. You know, the idea of making democracy work. I've done stuff with environment, and I guess I'm hopeful. Because it's not just a logical exercise. I'm hopeful because there are people who actually um, uh, are willing to do the organizing and the work that it takes to protect and defend the things that they believe this country's about. So there's times to be, it's like that expression of exasperation to my daughter. There's times when when you feel like just giving up, but you can't. And so am I living in a land of make-believe hope? Well, I may be, but that's where I am.
All right. Professor Abraham says that he worries that we'll fall into some kind of libertarian morass when we focus on some kind of Schmittian exception world. Seems to him that the disaster of recent decades has been surrender of public state power to markets. And Reagan's getting government off of our backs was rightly countered by Jesse Jackson's getting government on our side.
Oh, I mean, we've been in a neoliberal moment since at least Reagan, but probably it initiated, I would say, as a response to the Great Society. So I wrote a thing a number of years ago called living in the dwindling shadow of LBJ's America, right? And the neoliberal moment we're in, right, corresponds to two things. One is the idea that the normal function of government is always inefficient and ineffective. That's, I think we have to defend those places like those places where the government does things best. But the libertarian tradition in American political life is old. It's old. I mean, when you remember that there were mask riots, right, during the Spanish influenza, right? There were people who were refusing to wear masks, right? All that is tied back, I think, to kind of the libertarian strains in American life. I think those are going to be there, but as I've said to my libertarian friends, maybe they're not friends anymore. I said, libertarianism is an attitude. It's really not a political philosophy, right? Because it's not a philosophy that enables us to govern. Private law is a form of law, but it is still law, right? So it's not. We can't live in the libertarian paradise that these people imagine. So government's going to have to function, and the question is, how can we demand that it be on our side, right? So I agree with the question. I think I'm not so the neoliberalism. If you read the op-ed pages, is under severe stress because it in fact doesn't work. Right? It doesn't work. I mean, remember, the post office is in the news right now, but the reason the post office is being attacked is to attack a democracy, right? But remember what the post office is. Okay, remember what the post office is, right? Imagine this, right? Imagine, right, that for 49 cents, you can scrawl an address on a piece of paper, put it in a mailbox, and historically it would get to where you're sending it. People may complain about the post office, but it's a function of public institutions that actually work, right? The disinvestment in public schools is designed to make sure that public schools don't work, right? In fact, I don't know about you, but most of the people I know were educated, at least in K through 12, right, in public schools, right? That's a commitment that we have to rejoin as a bulwark against the further collapse of the solidarity that democracy relies on.
You have been doing work with lawyers in Latin America, and I'm wondering, given the history of Latin America with its problems of dictatorship and then the transition to democracy and some of the techniques that were used for population control in that context, do we have anything to learn from Latin America? And do you have any observations or comments with respect to how comparative law might figure into our struggle here, or international law and our allies throughout the hemisphere and, in fact, throughout the world?
No, I think absolutely. One of the things that I found that I'm gratified is the work I've done on what I've come to call demos prudence, which is the study of the way in which people make law, has actually been widely reproduced and republished in Latin America. So it means there's an audience for it, right? And so I've been working with some lawyers in Ecuador, primarily to try to make the plurinational promise of the Ecuadorian constitution a reality, right? So there's two things. One is there's the vision that we can learn from, but we also can learn that we have to protect against the tendencies towards autocracy. So yeah, I think there's comparative work, both comparative constitutional work, comparative institutional work is really important, and comparative histories. I mean, we can learn from one another. So no, absolutely. I mean, I think the idea that we spend so little time focused on Latin America in this country is it's an embarrassment, right? It's an embarrassment, right? Even when I was at the University of Texas, right, I would say, look, what is our comparative advantage? Our comparative advantage is Latin America. Instead we wanted to have exchange programs with England.
And there is an interest in questions regarding the relationship between your perspective in environmental justice and environmental racism and the COVID-19 pandemic. Do you see connections?
Oh God, yes. Sorry.
And what kind of connections do you see, and how does environmental law, can it be used to help deal with some of the injustices of the COVID pandemic, or is it a separate legal area?
Well, I mean, there's. I'm sorry to cut you off. I apologize. I mean, they're clearly present separate problems, but the comorbidities that make COVID more fatal, right, are found in environmental justice communities. Right, and the comorbidities in those communities are directly traceable to the environmental situations which they find themselves. So let's take something like respiratory distress. What we discover, right, is environmental justice communities, and I won't populate that for you, but you can imagine who they are, right, have far fewer chances to access green space. The tree cover in neighborhoods are less. When you discover that the more green space you have in a neighborhood, the lower the particulate matter that the air continues to hold, which then relates to respiratory distress, asthma, etc., and other comorbidities. They're absolutely related problems. And addressing the problems through environmental justice will help you address the kinds of things that make these communities more susceptible to the impact of COVID-19. Absolutely. There are many paths to Rome, right? And you can be an environmental justice lawyer and somebody who's working on COVID because they're the same stinking problem. One magnified by a virus, right? But the comorbidities are the things that make these communities more vulnerable. And we need to identify those comorbidities where they're attached to environmental, environmental conditions, and then attack and challenge the processes that created those conditions. So yeah, no, absolutely.
Wonderful, thank you. And I see we're starting to run out of time.
I got to run, yeah.
We got you for 3 more minutes. We got 3 more minutes.
Okay.
Just final words that you might want to say to our audience, understanding that it includes members of the practicing bar, of the bench. It also includes our law students who are members of the law school's Journal for Race and Social Justice, the Law Review. Do you have any last words of guidance in terms of how to continue to prepare themselves for the practice of law in this time and maintain a vision that puts before them the proper things to focus on?
Well, to the students, I would say it's going to sound really like, I'm going to sound like an old fogey, and I apologize, right? But you walk into law school with an empty toolbox. You better walk out of law school with tools falling out of that toolbox. You better put as many tools in that toolbox as you can. Be the best lawyer you can be. That is your responsibility, period. Full stop. Be the best lawyer you can be. To the bench, I would say you have to give, where you have published opinions, right? You have to give reasoned justifications for the rule, the decision you're reaching, and the orders are going to be bound by the rule of law. There's no question, and judges do that all the time. How you couch the order, and what you think the considerations that you took into account, even where the order doesn't directly respond to the things that you think are important because the law doesn't permit you to do it, you can still talk about that. And that, even though it's dicta, right, is still important because it becomes part of the discussion on how law ought to be at every moment democracy enhancing rather than democracy contracting. And if you believe that the people have a right to govern themselves, then what you want to do is enhance democracy whenever you can. And you can do it in a variety of places, period. So sorry to the students. I didn't mean to be such a, like a hard ass, but excuse me. But really, I mean.
Thank you, Professor Torres. Thank you very much. This is a virtual applause and a virtual heart.
Oh, thank you.
So thank you very much. And,
I look forward to the time that we can see each other in person.
I do too, very much.
All right, take care. Thank you very much. Thank you, all of you. I wish I could see you all. Thank you. Bye-bye.
Bye-bye. So now we're going to be transitioning. We have a minute or so. We're going to be transitioning to the first panel of the conference. I would like to introduce Elanny Lago as the moderator of our first panel. She is the Vice President of the Cuban American Bar Association, University of Miami School of Law Student Chapter. And I give it to you, Elanny.
Thank you. Good afternoon, everyone. My name is Elanny Lago, Vice President of the Miami Law Cuban American Bar Association chapter. I will be the moderator for this panel. This first panel will focus on civil rights issues exacerbated by the pandemic and the role of international legal institutions in protecting human rights, including the role of international courts, UN special rapporteurs, and the inter-American system in securing applicable norms to relating to states of siege, crimes of negligence, discriminatory policing, excessive use of force, and domestic violence and terrorism. The order of the presentation is as follows. Opening the panel, we have Professor Davis, who is a graduate of Harvard College, Harvard Law School, and Harvard Business School, and is now Professor of Law at the University of Toledo's College of Law. Then we will hear from Professor Gilchrist, who is a graduate of Yale University and received her JD from Columbia Law School, and is now an Associate Professor of Legal Writing at Brooklyn Law School. And next, our very own Professor Iglesias, who is a graduate of the University of Michigan and received her JD from Yale Law School, and is now Professor of Law here at the University of Miami School of Law. And following, we have Professor Bettinger Lopez, who is also a member of the Kane family. Professor Bettinger Lopez is a graduate of the University of Michigan and received her JD from Columbia Law School. Now she's a professor of law and the director of Human Rights Clinic here at the University of Miami's School of Law. And last, but certainly not least, we have Professor Lopez, who is a graduate of Northwestern University, received her JD from the University of Texas School of Law, and has an LLM from the University of Paris. Professor Lopez is now an associate professor of law and the director of the Community Lawyering Clinic at the Thomas R. Klein School of Law at Drexel University, and is also a member of the Harvard Kennedy School. This is an impressive panel, and as a moderator, I will be keeping time for each of our esteemed panelists that each have 10 minutes to speak. When each panelist has 2 minutes left, I will turn on my microphone and indicate to you, you have 2 minutes to wrap up. At the 10-minute mark, I will again turn on my microphone and say time's up. It's very important that the speakers be ready to hand the podium over to the next speaker when they hear that time is up. If each speaker does this, everyone will have their say and there will be a 15-minute question and answer period where the speakers can answer questions posed by the audience or add some final observations. Thank you all for being here today. We're excited to hear from you. And now I'm going to hand it over to Professor Davis to get us started.
Thank you very much. And I'd like to say on behalf of my grandmother, who came to the United States from Cuba in 1910, that I'm really honored to have Elanny as the moderator here. My grandmother would appreciate it. Ellis Island and everything. There you go. Way before Castro, okay? Anyway, I would like to try to answer the questions that were sent to us quickly here. The first question was, how has the pandemic exacerbated domestic violence and what is there to be done looking forward? The answer is that COVID is a violence. It's a violence that is implacable, relentless, and all that. That is the violence that is going on right now with 200,000 people dead. The second part of it is, the second sort of human violence is the response to COVID, which has been inept, unacceptable, and really criminal as a crime against humanity. So that is, the layers of violence are multifaceted in this country at this point in time. But I'm just trying to say you have to look at it as a systemic series of violence, which is the poverty of the response. I think you may have seen recently, everyone, that there was the issues of unconsented hysterectomies at in American concentration camps where some of the detainees are. That's just one aspect of it. There's limitation of liability laws for COVID that just got passed here in Ohio, for example. The PPE, the misrepresentation, all that stuff is a violence against all of us as Americans. So the next question is, how do international courts and legal institutions address the varying interests in the world? So I want to say that there's a rule of law, okay? We talk about the rule of law, but unfortunately inside the United States, we tend to think in terms of rule of law as being from our Constitution down. And in fact, it's more than that. The rule of law is also on the international plane in terms of the international legal obligations on the United States. The United States has treaty obligations. The United States has customary international law obligations that most of the time students may, and others, and judges and practitioners really don't think about. And it's a problem inside the United States because you're kind of caught in a shell game of a domestic without seeing the broader vision of the international legal obligations of the United States. And as an advocate, you need to. For example, George Floyd. There's a lawyer named Crump who represented George Floyd's family. I met him years ago representing Trayvon Martin's mother in Geneva at the UN Committee on the Elimination of Racial Discrimination, where they're raising in shadow reports concerns about that kind of violence against Black people with the United Nations Committee, which was reviewing the United States. And from those kinds of reports, there come out what are called conclusions, where they list a series of concerns that the international community has for the specific country, and all countries are reviewed under this. That is a weapon that you have for organizing for work inside the United States on a particular issue that you should take advantage of. There are other human rights committees also there too. Next, there is, inside of the US, there's international law and how it comes into US law. I'm not gonna go into a whole presentation on that, but there's some things that automatically apply in the courts and you should take advantage of those. And there's some things that don't, but you can still invoke them. We talked about dicta with Professor Torres. And I've seen, for example, in death penalty cases where people have raised issues under the International Covenant of Civil Political Rights in US courts, and the US judges have been forced to deal with it. Or if you look at the case which happened with regards to the Mexicans being held, Medellin, you probably know it, you'll see that in Oklahoma, the courts in Oklahoma said, well, there's a decision of the International Court of Justice. The United States has signed on to do something about it. And so I have to do something here in reviewing the death penalty conviction of the person there who ended up being commuted by the governor of that state. Other states didn't act that way, as Texas did. But the point I'm trying to make is these are the kinds of things that can be brought into US domestic law. Another aspect of this is, I guess I could call it comparative, which is international law plays in different ways in different countries. And the ability of those countries to address international law issues that are affecting people in the United States can vary. And there may be situations either under civil or criminal law in another country where, because somebody here is hurt who is a citizen of that country, those courts will have jurisdiction to address what's happened to them. Some of this is tried to be done, for example, in places like Spain, in places like Italy, and all. And that, so in those systems, under the criminal or civil system, there are opportunities that are there. And I would emphasize that those criminal actions in some states allow victims to be part of the criminal process. And it's actually very much more advantageous than our separate criminal civil systems in the states, because the victim can get the kind of wrongful death or whatever relief that's there. A third thing is that there are regional courts. So for example, with regards to torture, I want to emphasize that regional courts such as the European Court of Human Rights have made decisions about US torture that happen in countries in the European arena during the 44 country torture regime that the United States put in place after 9/11. And there are condemnations of our allies for what they allowed to happen on their territory. Those condemnations in turn serve as a basis for raising issues domestically with regards to what has happened in that setting. Beyond that, I just wanted to emphasize a couple things on systemic racism. You know, the Inter-American Court of Human Rights is going to take a look closely now about systemic racism in the United States. I just got a note about that being accepted. I mentioned the UN Committee to Eliminate Racial Discrimination. A third one is the International Criminal Court. The International Criminal Court is trying to investigate US torture that has been well documented here in our domestic system, but no prosecutions of high-level people have happened. But they're trying to document that and look at, investigate, and possibly prosecute individuals who put in place torture that happened in Afghanistan, which is a signatory. In the comparative realm, also for the COVID pandemic, and I'm seeing my time is, I have 2 minutes left. One of the things that's really important is that you got to not think just vertically in our system. In terms of inside the United States, you have to think horizontally. For example, workers who are working at Amazon have brought lawsuits in the United States about the state of the place where they're working in terms of protections, right? Well, guess what? Workers for Amazon have done the same thing in France. And they have some remarkable decisions from France where basically the French courts are saying to Amazon at its warehouses, it had a whole series of things to do under French labor law to make, in the pandemic, to make them safer for their workers. The lawyers who did those cases in France, in turn, can do amicus for the cases in the United States. because Amazon is playing worldwide. And if you're not playing at the same level worldwide, you're going to be playing like whack-a-mole, okay? And so by being able to think in terms of, well, how can I get some help from overseas, then I might be able to get to something that is possible. The last question is, what blind spots does the United Nations have in addressing human rights violations? The United Nations has all the blind spots that the political regimes of states have, okay? So, but I would say one thing in particular is that it is very difficult for the United Nations human rights organizations to individually condemn a country outside of the periodic reporting process. Because bad things like racism happen here, right? They happen in other places in different ways. So, for example, with the George Floyd resolution, very difficult to make a strict condemnation of the United States when that was done on Juneteenth. However, in the text, there's so much about the awfulness of the states with regards to that was allowed to be put in and raised at the international plane. With that, my phone has rung, Elanny is on, and I am now passing to the next person who is, which one, Elanny?
Thank you, Professor Davis. I would love to pass over the podium to Professor Gilchrist.
Hi, I'm Heidi Gilchrist. I'm so honored and happy to be here. And there was a question earlier about, because I actually had Together We Can Make Change, and somebody asked about being optimistic after all these years. And I do tell my students, I teach the social justice gateway to legal writing, even if whatever our small part that we can each do together, hopefully we really can effectuate change. And thank you to all the organizers of the conference. So basically, what I will start with, and the main theme, which you all know since you're here, is when the pandemic started, the first thing that I thought about since my whole career, or my academic career, I've been writing about all the terrible policies and laws that came out of the tragedy of 9/11, as Professor Davis was just talking about, such as torture. And so I immediately started thinking, what's going to happen with the pandemic in terms of civil and human rights, and that should remain, although obviously we're all very terrified of the disease, we need to also be thinking about all the bad things that can come out of crises. And so a lot of my writing has been about material support laws after 9/11, in which mostly Muslim young men have been jailed for decades, often in solitary confinement. And in many cases, especially in the case of attempted material support, they really didn't actually even do anything. They maybe said something prodded on by a government informant, and who were handsomely paid to get them to say something. And things like Arabic prayer cards were used as evidence of jihadist intent. So obviously I'm approaching this from, I have a national security background. And in all these cases, and very few of them have gotten any vindication. One man who went to the European Court of Human Rights, since the American courts were closed to him, so he got at least some vindication in the European Court after being tortured and rendition. And the theme in all these cases of the people who are trying to vindicate is never again. They don't want what happened to them to happen to other people. So obviously it's a very different crisis, but still we want to be thinking about these issues and the way they're hurting marginalized groups. And so it's a challenging time for the international community, but it also shows that we really do need to work together. The UN General Assembly last week approved a pandemic resolution, and they said it poses one of the greatest global challenges in the history of the United Nations, but it calls for intensified international cooperation and solidarity to contain, mitigate, and overcome the pandemic and its consequences. So we all obviously need to work together. If we get a vaccine, how is it best to distribute it? Because the virus doesn't respect borders, and we need to be alert as an international community to violations of civil and human rights. And in that vein, For example, in Hungary on March 30th, the National Assembly passed a special authorization law allowing the Prime Minister to rule by decree, essentially enabling the government to pass any regulations without a parliamentary vote and even to suspend Parliament. The international community, there was a large outcry, and so they did vote to end it, but most commentators agree that even though the rule by decree ended, that they can basically reinstate it at any time. So it's very scary. These are scary, can be scary times. And from this national security perspective, the pandemic also highlights how we need to be thinking more broadly. After 9/11, the law enforcement was so focused on surveilling often poor young men of color using government informants, and they were so focused on that they weren't looking at white supremacists and other issues, even like public health. And so one of the things I've always argued, we need diversity in these forces so that we have people to point this out. What might seem obvious to you or to me, if there's a kind of a group think, it's not happening. And there were travel bans even before the pandemic, and now we need to look at how those are being utilized. If we have laws, for public health, which are good, like we need masks, but we need to stay vigilant about uneven enforcement that really highlights inequities. And that happened in New York City with who was being disproportionately stopped by police. And in France, even though they are asking you to wear a mask in public, they have a law against basically burqas, and those remain banned even though you're supposed to cover your face in public. So it just shows how ridiculous the law is, or that law is. It's great to have I can't see any of you, but I'll have all different people thinking in different ways, because there's obviously things on a big scale and even smaller things, such as communities closing beaches to outsiders. And so we want to all think of all the different ways that that this pandemic can cause bad laws or policies. One of them being obviously, and I know the other panel will go much more in detail, is education. Closing schools does not have an equal effect. And there's obviously a human right to education. It's one of the most widely recognized human rights. So aptly put by the Brown Board of Education in these days, and that was in 1954, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education, and that's just only more so true today. And here in New York City, where the schools remain, de Blasio just announced yet again, they're not starting on there's children's shelters that don't have access to Wi-Fi. They don't have a pod to go to. And so it's really going to have this disproportionate impact even if it does open, going to school 1 day a week, is obviously not ideal. And then to sort of end on a happier note, people always talk about, and you might read about if you take it, now speaking to the students, if you take a course on national security, the tension between national security and human rights and civil rights. But there are times when they actually go together. I argue that security itself is a human right. People, education and it will help national security, healthcare, and so there is actually a time when they actually go hand in hand. So anyway, I think I'm out of time, but I see my moderator, Ilan, but continue the discussion, email me, I'd love to further conversation.
Thank you so much. And next, I'd like our next panelist, Professor Iglesias.
I want to spend a little bit of time focusing on the philosophical understandings of the framers that they had with respect to political violence. On the one hand, they invoked themselves the right of revolution in separating from England. And on the other hand, America was designed to be of and for a people under law, not a lawless sovereign. So on the one hand, you have the issue of the legitimacy of the state. And then on the other hand, you have limitations on freedom necessary to secure identity, specifically the identity of a people, us, as an intelligent and law-abiding people. There are clauses in the US Constitution that can only really be understood in light of the framers' understanding of political violence: the suspension clause and the militia clauses of Article 1 and the Republican guarantee of Article 4. Now, in this presentation, I want to focus on political violence during the COVID-19 pandemic. While political violence is not new, there are elements of the violence we observed that are new, and these elements create a different kind of threat to the order of legality that's established by the Constitution. This unprecedented threat requires serious reconsideration of some basic assumptions and formulations of constitutional law, as well as our understandings of our obligations under international law. And so then I'm going to close with summing up in simple terms two of the main aspects of President Trump's use of political violence that pose unprecedented threats to the constitutional order in the United States. Next slide, please. This is a quick timeline. I'm just going to focus on January 9th, which is when the World Health Organization announced a mysterious coronavirus-related pneumonia in Wuhan, China. And then March 13th, President Trump declares COVID-19 a national emergency. And March 19th is the first state, California is the first state to issue a statewide stay-at-home order. Next slide. This is a timeline from the Kaiser Family Foundation. And just to note a few of the states after California, you see March 21st, there's another group of states. Then on March 24th, you see Michigan, Massachusetts, New Mexico, etc. You don't see Florida until April 3rd, but you do see that, therefore, that the response was not uniform across the country and it was not controversial, not uncontroversial. Next slide. So this is gridlock around the Michigan State Capitol in Lansing, organized on April 15th. The purpose of Operation Gridlock was to jam the streets around the Capitol to protest the governor's stay-at-home order. This is not particularly problematic. Organizers asked the people to stay in their cars, and most of them, for the most part, did, or a small minority didn't. Next slide. Then 2 days later, Trump, on April 17th, tweets his "Liberate Minnesota, Liberate Michigan, and Liberate Virginia, and Save Your Second Amendment, it's under siege" tweets. Well, next slide. A message received. This is the Patriots rally at Michigan on April 30th. Armed protesters seek to enter Michigan legislature to pressure them not to extend the governor's emergency powers. The police allow them to enter the Capitol building. What the protesters did not achieve with Operation Gridlock on April 15th, they achieved on April 30th. The Michigan Senate refused to extend the governor's emergency declaration. Now, when armed protesters breached the state capitol in Lansing, Michigan, rather than assuring the people of this country that the federal government would protect the state government against efforts to overthrow its policies or its leadership through violence or the threat of violence, Trump tweeted that the Democratic governor, Gretchen Whitmer, needed to make a deal with them. These are very good people, but they're angry. They want their lives back. See them, talk to them, make a deal. Now, these people call themselves militia, but they are not militia in the constitutional sense referred to by the clauses of Article 1, a well-disciplined militia. These are members of a group that call themselves the Michigan Liberty Militia, but this group is listed as an anti-government group by the Southern Poverty Law Center. Next slide. Now, liberate means to set at liberty, specifically to free something such as a country from domination by a foreign power, a hostile power, by an enemy. And the fact that the President of the United States is using his position in office to instigate violent opposition to lawful state government policies and leaders makes the anti-lockdown protests different in kind from other instances of political violence. And that unprecedented nature calls for rethinking some basic constitutional doctrines. Next slide. So Article 4, Section 4 of the Constitution is the Republican guarantee. It has two clauses, both of which impose affirmative obligations on the federal government. The first clause is an obligation to guarantee every state a Republican form of government and to protect each state against invasion. The second clause is to protect the states against domestic violence in response to requests from state government. This clause has historically been interpreted as non-justiciable based on an early SCOTUS decision holding that whether a state's government is Republican is a political question to be resolved by Congress. But I'm interested in revisiting this question. I think there are very strong reasons to insist that it is a legal obligation binding on both political branches. And I think the case is strong as a matter of original understanding and the minimal content of the words for them to have meaning. I can talk about that if interested in the question and answer. Next slide, please. Now, the pandemic violence is an act in two parts. And the second part begins on May 25th. And as stated in the first paragraph of a complaint filed by lawyers for the ACLU in DC on behalf of Black Lives Matter protesters who on June 1st were violently dispersed from Lafayette Square by order of Donald Trump, George Floyd on May 25th was arrested by the Minneapolis police. In the process, he was handcuffed and fell to the pavement. A police officer placed his knee on Mr. Floyd's neck, and for 8 minutes and 46 seconds, he kept it there until George Floyd died. Next slide. The reaction to the protesters in Lafayette Square protesting the murder of George Floyd was quite different from the police reaction to the anti-lockdown protests across the nation. So was Trump's reaction. On May 28th, Trump tweets, "When looting starts, the shooting starts." The protests continued and spread throughout the country. And the next day, June 2nd, Trump threatens to invoke the Insurrection Act. We did not hear anything about the Insurrection Act in April during the anti-lockdown protests. The important thing to know is that the act is a statutory exception to posse comitatus, which prohibits the use of the military in domestic enforcement. Trump did deploy federal agents into cities and states around the country, and in Oregon, this became a public confrontation on July 18th when the governor publicly objected to camouflage federal agents without identification abducting protesters in unmarked cars. Next slide.
Professor Iglesias, we're at the 2-minute mark.
Thank you very much. I'll be wrapping up. 2 days later, on July 20th, members of the US Senate and House responded by introducing Preventing Authoritarian Policing Tactics in American Streets Act. Among other things, it would require federal agents to wear identification and to use marked cars. The interesting thing is that the House version focuses on Article 1, Section 8, the enumerated powers of Congress to legislate. I will recommend that they add Article 4, Section 4, the Republican guarantee. It is Congress's duty first and foremost to secure to each state a Republican form of government, and preventing unidentified paramilitary agents from arresting people without probable cause and throwing them into unmarked cars is fundamental to Congress's fulfillment of that obligation. Next slide. We're going to skip this. This has to do with an international perspective on this that we can talk about. In the question and answer. So I'm going to wrap up with the last slide. Next slide, please. Going back to the philosophical question about the kind of liberty that informs the US constitutional order. The markedly different responses to the anti-lockdown and Black Lives Matter protests can be approached from two perspectives. One views them as completely arbitrary and ultimately incoherent. The arbitrariness of Trump's response conjures a running battle between two concepts of liberty. One is that liberty is absolute freedom. No one, the president included, need to be consistent or coherent. Liberty is a matter of will and willfulness. The other version of liberty is liberty under law, which requires coherence, where liberty is not a matter of will, but of intelligence. The second view is that these are not arbitrary at all. This is racially motivated differential treatment. And now the idea of absolute liberty and the project of dividing American people into two opposing factions that totalize the political field is extremely dangerous and should be rejected. And I propose that we should reject Trump's example of absolute freedom and his invitation to a racial war. And we should do it in the form established by the Constitution, as Hamilton said in Federalist 21, that to change the government is by changing the leaders through fair and peaceful elections. And thank you very much.
Thank you, Professor Iglesias. And now I would like to call up to the virtual podium, Professor Bettinger Lopez.
Hi there, can you see me okay?
Yes.
Okay, great. Hi, everybody. Sorry, I'm in transition right now, so I'm camping out at my parents' house. It's such a pleasure to be here. Thank you to Professor Iglesias, my wonderful colleague at University of Miami, as well as the entire AV team and our events team for putting this awesome conference together. It's great to virtually be with everybody. So my presentation is going to focus on domestic violence before, during, and after COVID, when that might be. And I want to pick up on a lot of the themes that we've already seen discussed in this convening. And I'm going to really span social science, criminology, and civil and human rights arenas. Really, this is a conversation, as Professor Iglesias was just mentioning, about pandemics upon pandemics. So around the globe, governments, of course, have been imploring residents to stay home since March and to protect themselves and others from COVID. But for domestic violence victims, the vast majority of whom are women, children, and LGBTQ individuals, home is a dangerous place. And so when we look at data from around the world, we see that by and large, there has been a lot of documentation of increases in domestic violence since the COVID pandemic took hold of our world. For example, in the Middle East and North Africa, UN Women has documented that in the Palestinian territories, for example, there has been a significant increase in gender-based violence, and they warned that the pandemic would likely disproportionately affect women, exacerbate pre-existing gendered risks and vulnerabilities, and widen inequalities. A study from Bangladesh this summer confirmed those numbers with some more granular data showing significant, like 50–60% increases in domestic violence in the areas of sexual violence, physical violence, and emotional violence in a study of about 2,000 women. They also have horrific data on food insecurity, really underscoring that economic insecurity is both a cause and consequence of gender-based violence. The two are quite connected, and it's so important that we make sure that we note that, and that international bodies are focused on that connectedness as well. Latin America has been interesting. Countries like Mexico and Brazil, we've seen spikes in calls to hotlines, suggesting an increase. But on the other hand, we've seen a drop in formal complaints in other countries like Chile and Bolivia. And experts have attributed that likely to movement restrictions or to the inability or hesitance of women to seek help. And of course, many of us are having these moments where we're in conflict about what our interaction with others in society should be, let alone others who may be at high risk of exposure to COVID, such as law enforcement or our health systems. And so these are complex reasons about why people may or may not be seeking help in this time for domestic violence or for anything else. There's a recent study from the United States by my colleagues, my new sociology colleagues, Alex Piquero and Nicole Leeper-Piquero, showing a 12.5% increase in Dallas, Texas, in domestic violence cases after local stay-at-home orders went into effect. So researchers have a pretty good sense, and if you speak to any domestic violence advocate, they will confirm this, that domestic violence rates have increased in COVID. But it's really important to underscore that gender-based violence is not caused by COVID. It is not being caused by this pandemic. Back to the comments that Professor Torres made in the beginning, it's really important to kind of underscore how this pandemic has surfaced and revealed many pre-existing inequalities. And here, inequalities in gender power dynamics and toxic masculinities have just been surfaced. They've been exacerbated. If you look at data from before the pandemic, the United Nations has said that 243 million women and girls worldwide are subjected to sexual or physical violence by an intimate partner in a 12-month period. And so you put that a different way, 1 in 3 women has experienced physical or sexual violence at some point in her life, and LGBTQ individuals have similarly high levels of violence. And so you take these numbers pre-pandemic, and then you think about exacerbated numbers post-pandemic or during the pandemic, and you ask the question, why? Well, rising numbers of sick people, growing unemployment, increased anxiety and financial stress, and a scarcity of community resources have really set the stage for this exacerbated crisis. Many victims are finding themselves in violent homes without access to resources or family and friend networks. And abusers can experience heightened financial pressures and stress. There's been increased consumption of alcohol and drugs that has been documented, purchasing and hoarding guns as an emergency measure. And so many have called this a double pandemic, or the invisible pandemic of domestic violence. They've called it a ticking time bomb or a perfect storm. We've seen, of course, shortages in social services and assistance, both in the personnel who can be available, as well as money that has been drying up or being channeled to other places. Social, legal, health, and health service providers, shelters, food banks, legal aid offices, child care centers, healthcare facilities, and rape crisis centers are overwhelmed and understaffed. And the criminal legal system has been another place that has been very vexing from a civil and human rights perspective when one thinks about gender-based violence. Prisons have become hotbeds for the spread of COVID. We knew they would be, and they have unfortunately become that. And so many criminal justice authorities have halted arrests or released inmates, and these are critically important public health measures. But at the same time, they need to be accompanied by some sort of alternative means to prevent and interrupt domestic violence, including individualized risk assessments or efforts to notify victims of pending inmate releases, and safety planning and support for victims. And so as we think about some of the questions that have guided this panel about balancing of rights, we want to make sure that we are thinking about the rights of all individuals, those who are in carceral facilities and those who have survived domestic violence. And it's not an easy matter at all from a policy perspective or from a safety perspective to figure out how to balance those rights. And so international bodies need to be grappling with this, as do, of course, governments. And so just a couple notes from the international community. The Inter-American Commission on Human Rights and the United Nations have emphasized that countries need to incorporate a gender perspective into their responses to COVID-19. They've underscored the importance of responding to the increases in gender-based violence. We've seen innovative steps from many countries in this direction. For example, hotlines or text message-based recording, mobile applications. France extended many hotel rooms to domestic violence survivors. Canada developed a new hand signal that somebody could make while using virtual technologies. And we've seen, of course, this increased reliance on technology, and that's included in virtual court hearings, which have become now in the United States a basic framework for courts dealing with domestic violence. And this has raised all sorts of questions. Many advocates say that it has increased access for some victims to justice systems, while many other advocates say that, of course, victims and survivors who don't have access to technology may be further disenfranchised from systems from which they're already disenfranchised. And so moving forward, I think it's critical that states support the development of many things. Here's a little bit of a laundry list. Alternative reporting mechanisms, expanding shelter options, strengthening the capacity of both the security and justice sectors, maintaining sexual and reproductive health services, which is where domestic and sexual violence victims are often identified and supported, supporting independent women's groups. Women's movements are critical for ending domestic violence, finance economic security measures for women workers, especially those who are on the front lines or serving in the informal economy, and focusing on the groups that are most disproportionately affected by the pandemic, such as migrant women, refugee, homeless women, trans women, and we need to collect comprehensive data on the gendered impact of COVID-19. I want to just speak for a moment. Do I have one more moment?
Yes, Professor Bettinger, you have 2 minutes to wrap up.
Okay, I'm so sorry about the lighting here. It's terrible. Okay, so just to speak for one moment about this, what I'm going to call a trifecta in our current moment of the COVID-19 pandemic. we have a deep global recession, we have the pandemic, and we have the civil unrest over the systemic and overt racism by police and demands for accountability for the murders by police of Breonna Taylor and George Floyd, Tony McDade, and others. And we've seen that the Black Lives Matter movement and the defund and the abolition movements have gained steam in the United States. And many anti-gender-based violence advocates and scholars are taking a really hard and critical look at the reliance of the movement to end violence against women on the criminal legal system, for which law enforcement often serves as the gateway. And so many critics, people who have criticized the criminal legal system in the past, have underscored that they don't want the public or legislators to use domestic violence victims to derail police reform. They think that it's critically important that we seek new approaches that avoid the unintentional negative consequences of the criminalization of abuse, especially in the context of the current pandemic, where, as I mentioned, there could be deadly consequences for people who are incarcerated. And so I guess just wrapping up, I think that this is like forcing us, this moment is forcing the anti-violence against women, anti-gender-based violence community to really come to terms with what alternative justice frameworks might mean. Frameworks that we might call violence interruption or restorative justice. There's my timer. Community justice, collective healing, economic justice, health and housing justice, and police abolition. And I think that it's critically important, and I will wrap up in 1 second. I think it's critically important that we do a deep dive and we deeply fund initiatives in these spaces as governments, as foundations should be funding this, governments should be funding this, the private sector should be investing lots and lots of money and time and thought and effort into exploring alternatives to the criminal legal system. But I don't think, and this is my personal opinion, I don't think we should give up on the criminal legal system altogether at this very moment in time. I don't think we can. Whether we should or not, I don't think we can. And so I think we need to, at the same time that we are making really deep efforts to reform the system as it relates to violence against women, I think we need to also be looking at ways we can improve the system and improve pathways to safety for survivors who choose to engage with the system, and then also create pathways to safety for survivors who don't. And I think our international legal bodies need to be dealing with that as well. So I'm happy to talk more in the Q&A. Turning it over to Rachel now.
Yes, thank you, Professor Bettinger. Professor Lopez, you can go ahead when you're ready. Thank you.
First, I just want to start by thanking you so much for inviting me to be here today. It's such an honor to be on this really incredible panel. And a lot of my remarks are going to echo some of the things that were alluded to earlier on. And so I want to harken back to actually my professor, Professor Torres, who was actually my professor in law school. And he made this remark that the law should be democracy enhancing. And one of the things I'm going to touch on today is what happens when it's actually democracy threatening. How do we as lawyers, what role do we have as lawyers in a time such as the one that we're currently facing, when many of the laws that have been put into place actually impede justice and expose many vulnerable people to increased persecution. And so I'm in particular going to talk about sort of the modalities of lawyering. We've heard a lot about what the law is, but I'm going to talk specifically about the role of lawyers in this unique moment, and in particular about the work that I've been doing here in Philadelphia as director of the Indian Windstorm Community Lawyering Clinic. So in the resistance movements and BLM demonstrations following the murder of George Floyd, I became involved in representing and advising activists, protesters, and residents who are subject to police violence. And I've been representing communities and activists for many years as a community lawyer and a movement lawyer, but somehow this really felt different to me. And so this presentation is really an attempt to describe and qualify what that difference was, what I really felt as I was doing this work. And what I found is that this time really demands something different of lawyers than has been required of us in the past, a different type of modality. In the interests of justice and anti-racism, at times we will be required to resist the rule of law when it fails to protect the vulnerable and achieve justice. And this is counterintuitive for lawyers for obvious reasons. It actually requires us to resist and defy our legal training in some instances, forcing lawyers to resist some of the conditioned instincts and assumptions that have been brought to us through years of legal training and practice. And I've come to use the term resistance lawyering to describe the efforts that I've been involved in over the last few months. Resistance lawyering, much like community lawyering and movement lawyering and rebellious lawyering, is centered on communities and activists working on the ground. However, there's a difference here that I would like to denote that I think is unique in the sense that there is an explicit orientation for resistance lawyers really against the law at some periods of time. And this really demands, of course, a heightened sensitivity from us as lawyers to know when it is appropriate to transgress the law and how to do so in ways that are principled and prevent us from falling into anarchy. For me, human rights law has become a compass to guide my transgression of the law of law enforcement, and I'm going to describe that as well. I want to give you first a bit of context to the work that I've been doing here in Philadelphia. And so I'll start by introducing you, and I think the best way to do so is for you to experience sort of the moments we've been having in Philadelphia as I have when I first saw a video that has been posted to Twitter. So if we could cue the video real quick. So what you don't see in this video and what was described to me later is how protesters, this was at a Black Lives Matter protest on June 1st in Philadelphia. And what you don't see in this video is how police corralled protesters from both sides, essentially forcing protesters to scale up a steep hill and scale a fence that basically was impossible for many to scale. They were repeatedly pelted with rubber bullets and tear gas. This causes a stampede. Even after some protesters were arrested, police pulled down their masks and sprayed them directly in the face at close range. And this was all, of course, during a pandemic. My clients described being unable to breathe, feeling like they would die on that hill, and seeing blood and hearing screams everywhere. As the days unfolded, it became clear that this was not the only act of police terror in the wake of George Floyd's death, and this galvanized me to use my legal skills to resist. Now it's culminating for me in a submission to the UN Rapporteurs on extrajudicial killing, freedom of association and peaceful assembly, and racial discrimination, alleging human rights violations on the part of police and city officials that will be filed with the ACLU at the end of this month. So what has this taught me about the nature of lawyering? So really it's taught me that part of the resistance that's required is really a resistance to some extent against our legal training. And so I'm just going to give a few examples in the interest of time here. So one is I found that I've had to resist my instincts as a lawyer to engage in really a formality that's sometimes impossible in the context of resisting lawyering. So I've had to communicate with prospective clients via Twitter, for example. I've had some relational fluidity with some of my clients who are also, experts in what happened. And so I've had them, read through various filings to ensure that I'm getting all the facts correct. I've also learned that I have to resist my own deference to authority that's been sort of ingrained in me. What happened here in Philadelphia is that the Mayor Jim Kenney and Police Commissioner Outlaw justified the acts that you saw in the video. They said that protesters were throwing rocks, they rushed police and surrounded a state trooper's office. There was actually no evidence of this, and aerial footage actually contradict that account. But they still continued to stick to this account until the New York Times released a video essentially showing that these allegations were unfounded. And within hours of the release of that video, the mayor apologized, even though acts of violence continued shortly thereafter. Another thing that this experience has really taught me is that, much like community lawyering, we really need to be responsive to the needs on the ground. So at first, what this required of me is direct consultation with protesters that were injured and trying to figure out the landscape of police accountability. But then this sort of modality of lawyering really shifted in some really prominent ways. So as I will discuss in a minute, I started to increasingly see the value of using human rights mechanisms to address and really resist the law as it exists in Philadelphia in terms of the use of force by police. Finally, I want to make the point about resisting being a blind steward of the law. So this is probably the most salient point and the most related to the difference between resistance lawyering and some other modes of lawyering. As a result of my representation of many protesters, I came in contact with a lot of other lawyers who were also filing different actions and engaging in different litigation as a result of the clients. I really became to see very clearly of the limitations of those other modes of action. So in particular, there were many civil rights attorneys who filed civil suits and sought money damages. Many of my clients felt that money damages were not going to be sufficient to really achieve what they were trying to achieve, which was accountability of police and social change. And so that's where the turn to human rights law became really important. Another thing that I found particularly troubling is that a lot of these lawsuits and the lawyers involved hamstring the efforts of my clients to achieve broader social change by advising them that they should not speak to the press and tell their stories to the public. And in this way, it limited the activism that my clients hoped to engage in to challenge police power and city brutality. So what's become sort of really interestingly apparent to me is how human rights and my use of it here can be subversive. And I guess it's important to note that, as Professor Davis said, human rights law and mechanisms suffer from many of the hierarchies and challenges that domestic law do. But what I want to highlight here is that in some ways it can also be a way for us to navigate these murky waters of when we're challenging the law and the figures that are supposedly meant to uphold the law. And human rights for me has become a compass to guide my efforts. So what do I mean by that? Well, human rights law in this instance has been a bellwether for socio-legal change, in particular because the human rights principles and doctrines that are laid out in the treaties that the United States is bound to provide a set of more robust protections of protesters, particularly peaceful protesters, and also more fully fleshed out guidance on the use of force by police. And so I can talk more about that in the Q&A if that's interesting. I've also found that human rights can be incredibly empowering in the sense that it creates more room for collective engagement and consultation because it really operates in many ways outside of the paradigm of the traditional attorney-client relationship. And it, in a way, lends itself very clearly to community organizing because it is in many ways structured to be a more collective endeavor. Thirdly, and this I think is a really interesting realization that I had over the course of working with some of the civil rights attorneys is that, in these civil suits, there's a real focus on sort of proximate cause. And it prevents us from understanding some of the more historical antecedents and policy policy roots, sort of the root causes that caused the violence that occurred here in Philadelphia. And in this way, the human rights mechanisms that we're currently engaged with allow for a more robust explanation and accounting of the historical racism that has led to the current police practices in Philadelphia.
Thank you. Oh, I think we're now going to transition over to the question and answer portion. And I invite all our panelists to turn on their cameras. And now while everyone's turning on their cameras, I guess I'll start with some of the questions some students have submitted. And you can feel free to jump in as you see fit. So one of the questions we got relating to international law was, what blind spots does the United Nations have in addressing human rights violations? What would you say their blind spots are?
This is Carrie Bettinger Lopez. I'm not able to start my video. It says the host has stopped it, just so you know. Okay, there we go. Well, as long as I'm talking, I'll just say, just picking up on something in my presentation that, I think, as I mentioned, I think human rights bodies have largely followed U.S. and other largely kind of northern and developed nations in the criminalization approach to domestic violence. And so, for example, the United Nations Special Rapporteur on Violence Against Women just put out a call for proposals on evaluating the criminal regimes of countries regarding violence against women. And that is an area that I think there are very diverse opinions of across the world. I spoke with a colleague in Jamaica recently who said, you all in the US are having, are tearing your hair out about the criminal legal system and its unintended effects. And here in Jamaica, we've actually never seen it operate effectively enough to call domestic violence a crime, right? So, this is an area that I think the international community and international human rights bodies need to deal a lot more with. They need to just dive into that conversation and start by acknowledging that there are many diverse perspectives on the efficacy of criminalization, and they need to gather together folks from across the world who have had different experiences with that and different perspectives, and then force themselves as international human rights bodies to start grappling with that through rather than just kind of following the direction of more developed countries and wealthier countries that have kind of taken a certain heavier stand on criminalization. So that's one thing I would say.
Yeah, if I could jump in on that too, I would just say that there is, related to the specificities of each country, there is this idea of margin of appreciation, right? Which is that each country does things a little bit differently from the uniform rule, okay? And so one of the issues is to what extent that margin of appreciation actually works to subvert the human rights rule that is trying to be aspired to as a uniform rule. And a second thing is that depending on how the dynamics are, there can be this kind of sort of neo-colonialism, if I can call it like that, of sort of if you have a Western dominated vision and then they're trying to be exported around to developed countries as to the way you should do it, that can be actually a kind of colonialism that doesn't hear what's going on in the individual countries and the structures to address every single one of the types of issues that are there. I'm going to give an Indonesian example that I find fascinating, is that people who don't wear masks, apparently in some town in Indonesia, they have to go and bury the COVID-19 people who've died of COVID-19 in that little town. So you don't want to wear a mask? Okay, the town says you have to go bury the people dying of COVID-19. So you see, we are really all tied together. We don't think like that in the United States, right? But I think in a more communitarian vision, that's a very powerful way to get the message across about having to wear a mask or something like that.
And we had some students also ask if you can elaborate on what is remedial heterogeneity, and if you can elaborate a little bit on that, and also if Professor Lopez can kind of touch on her last point during her presentation.
Sure, I'm happy to just quickly pick that up. So the idea of remedial heterogeneity is essentially that in human rights law, you can request things. It's not so generic or limited or narrow, the remedies that you can request in human rights proceedings. So for example, you can request policy reform, you can request memorials, you can request reparations. And so in this way, it's much easier to work with collectives and communities of people that want to chart out a different vision of what justice looks like. You don't have sort of the narrow understanding of money damages being the way to make someone whole. And that's really important when we're thinking about widespread violence like we're seeing in many cities across the United States.
And if I could just jump in for a second and say that the other aspect of international law and its relevance to our situation, on the one hand, there's international institutions. On the other hand, there's the whole question of how the United States legal constitutional framework absorbs, embraces, and enforces international law. And I think that's incredibly important when you notice that in the news this morning, the breaking news is that in the process of preparing to disperse the protesters at Lafayette Square, federal officials were looking for devices to emit deafening sounds and to make anyone who's in the range feel like their skin is on fire. The use of force against public assemblies under international law follows basic known categories of international law, principles of necessity, of proportionality, of discrimination between those who are involved in the unrest and those who are not, and the infliction of pain, which is prohibited, especially if it arises to torture. All of this egregiously unlawful, and it raises the question of what is the status of international law and respect for international law and the role of federal courts in enforcing international law, separate and apart from Congress and the president. And by that I mean the direct relationship between federal courts and international law as understood in the original design is something that has been attacked over years since not just 9/11, but before 9/11. Beginning with the Reagan administration's introduction of the unitary executive. So I do think that's the other aspect of international law that has to be recognized, that how we enforce it and incorporate it in our own legal scheme is important.
Oh, sorry.
Yes, go ahead, Professor Davis.
I just wanted to add that you have the international legal instruments, and then you can look into your constitutional, federal, and state law to see how, where, to what extent they vindicate the international law rule. Even if the international law rule is not per se applicable in a court, there may be state constitutional, state statute, federal constitutional, federal statute, or one of those two, or the way that international law kind of comes in, that you can use to vindicate the issue that you have. It might be a water shortage rule or something like that, that actually vindicates an environmental racism thing, you know, and that's part of that resistance lawyering creativity that that you can do as a lawyer inside a system, in addition to using the international spaces too. But I really liked what Rachel Lopez was saying about the international system kind of takes you outside of the whack-a-mole.
Professor Davis, I think you broke up for a second there. So I'm just going to go ahead and mention the next question, which kind of ties into international interest that Professor Davis kind of alluded to. The question is, how do international courts and legal institutions address the varying interests in the world? That's to say, what factors are weighed and what information is considered when establishing laws that ultimately affect the world?
Well, for courts, it's a classic kind of international court question, which is always they have to decide on their own jurisdiction, whether they in fact have jurisdiction over the particular type of matter that is there. And secondly, the substantive law of what is the international, what are the legal instruments under which that they are able to grant some kind of relief or not. There may be treaties in the background that govern how they're structured. This is one of the issues, for example, the International Criminal Court. I was involved with an effort to address the priest abuse stuff at the International Criminal Court, and a complaint was filed by a group called Survivors Network of Those Abused by Priests from Toledo, against the then Pope, and believe it or not, the then head of the doctrine of the faith. And one of the issues is that a lot of the abuse had happened before the court had been established, so they couldn't address it. However, they said that you know, we're not going to do something for now. And the two words "for now" ended up being a very powerful signal that there was an issue that was worldwide inside the Vatican with regards to this kind of priest abuse. That's, you know, and even not starting an investigation ends up having an impact, because people around the world started to contact this Toledo group from 65 countries talking about what they'd experienced in their country. And all of a sudden this thing became an international organization of all these people who thought they were alone in different parts of the world, you see. So there's all these things that happen that are on, I don't know, additional aspects of when you take it to the international plane.
Yeah, I'll also mention, you know, a really important factor that's often considered by tribunals when they're implementing the law, but also in some of the foundational treaties, which is, when is it appropriate to intervene in sovereign matters? That's sort of one of the principal tensions in international law. When is it okay for international bodies to reach into domestic issues and sort of make proclamations about what's appropriate? And I've recently authored a law review article on this called The Law of Gravity, looking at gravity as one of the central organizing features of international law, and really is meant as one of the ways in which what are called erga omnes obligations can arise, which allow for more of an international interest in an issue. And I guess I will say that this sort of ties into another point that I didn't have a chance to make, but I'll make here now, which is, I think that there's some ways that international law can be democracy promoting, in the sense that it's just another check and power, another check on executive power that, unfortunately, because of the way that our laws are structured, and sort of getting to Professor Iglesias' point, how we've incorporated international law really limits its effect here at the domestic scale, at the domestic level, which in fact inhibits it from being a check on our executive powers here in the United States. And I think that is really a different feature of how international law plays out here in the United States.
I would now like to thank all our panelists, Professor Davis, Professor Gilchrist, Professor Lopez, Professor Bettinger Lopez, and Professor Iglesias for participating in our first panel. And thank you to all the students who submitted questions. So a round of applause, thank you. And with that, I'd like to pass it over to moderator David, who will be moderating panel number 2. Thank you all for being here today.
Good morning, everyone. How's it going? My name is David Petrantoni, and I will be the moderator for this panel. This panel will focus on the way the pandemic has uncovered civil rights issues arising out of detention, surveillance, crowd control practices, and policies directed at immigrant populations and at protests against stay-at-home orders and in support of Black Lives Matter, including the constitutional doctrines that reduce police accountability and the pending legislation to increase it. So it's my pleasure to introduce our speakers. We'll have Gilbert Carrasco, Professor of Law at Willamette School of Law, an expert in civil rights law, immigration law, and constitutional law. Then we will hear from Professor Darren Hutchinson, the Associate Dean for Faculty Development at the University of Florida, Levine College of Law, where he holds the Raymond and Miriam Ellerick Eminent Scholar Chair and focuses on constitutional law, critical race theory, law and sexuality, and social identity theory. After that, we'll hear from Danielle Jeffress, an assistant professor of law at California Western School, whose research focuses on theories of punishment and the law and policy governing prison and detention, with an emphasis on the for-profit prison industry and immigration-related confinement. Then we will hear from Scott Skinner Thompson, an associate professor at the University of Colorado School of Law, with research and teaching expertise in constitutional law, civil rights and privacy law, and including a particular focus on LGBTQ and HIV issues. So as moderator, I'll be keeping time for our panelists. As before, each panelist will have 10 minutes to speak, and then when there's 2 minutes left, I'll give each a time alert. After they conclude, the next panelist will begin their 10 minutes, and so on. After each panelist has had a chance to speak, there will be a 15-minute question and answer period where anyone can submit their questions for the panelists to answer. Now, with all this in mind, I'd like to give our speakers a warm welcome to this panel. Thanks to all of you for being here. We're very excited to hear from you. So I'm going to hand it over to Professor Torres, and let's get started.
Hello and welcome, everyone. I want to thank Professor Iglesias and Dean Varona for facilitating this conference, a very timely one indeed. And my talk is going to focus on the problems that have arisen as a result of the federal government's actions on many fronts. Beginning with the Black Lives Matter movement, we have seen demands for justice, demands for change, and demands for accountability. We've seen many protests and abuse of power around the country, and we have also experienced a rather draconian kind of approach by the Trump administration to peaceful protests. I want to focus on the initial involvement of federal agents at Lafayette Square across the street from the White House. They facilitated a photo op in front of a church for the president, and in the process, tear gassed many protesters en route. That is a major problem in the time of coronavirus. The reaction to tear gas is quite extreme. People cough and tear up and have a variety of issues that are really a potential super spreader kind of event, particularly in close proximity to other protesters. And we saw that again here in my hometown of Portland, Oregon, where 45 federal agents without insignia, without badges, in camouflage fatigues instead of uniforms or identifying attire, came into Portland uninvited and essentially accosted and abducted peaceful protesters. There were some who were struck with rubber bullets in the face, requiring surgery. There were others who were protesting as a group of veterans. One Navy veteran had a very large Navy sweatshirt on, big letters, NAVY, and he was tear gassed in the face at very close range, and a bone was broken in the process of trying to clear him out of the way. There were other protesters who were swept off the street, put into unmarked vans by these camouflaged little green men, as they would be called in Ukraine, and the occupation of the Crimean Peninsula and Donbass, when you had Russian troops coming in and basically invading Ukrainian territory. The same thing happened in Portland. And we have a lot of other issues, most recently perhaps the involvement of the federal government in the hysterectomies at the Irwin Detention Center in Georgia, non-consensual hysterectomies of immigration detainees, and the possibility that federal officials were deliberately indifferent to those activities. We also have the required work, labor of immigration detainees in federal facilities with little or no pay, without really volunteering for such activities. And so there are a lot of actions of the federal government these days that give rise to deprivation of constitutional rights. What I'm addressing today is the problem that these deprivations do not allow for a remedy in damages against federal officials. We begin with the 1971 landmark case of Bivens versus 6 unknown named agents of the Federal Bureau of Narcotics, where Justice Brennan for the court announced a new regime, essentially. He basically said, notwithstanding that there is no analog to 42 USC section 1983 with respect to federal officials, there is an implied right of action to sue the federal government, particularly federal actors, for deprivation of constitutional rights. There we had a man who was invaded in his own home without a warrant. He was manacled in the presence of his family. He was carted off to the police station. He was booked and released without prosecution. He sued, and the court agreed that he should be allowed to recover damages for those deprivations of rights. In the process, Justice Brennan for the court quoted from Marbury versus Madison, saying, "The very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury." This is a basic cardinal principle of constitutional law, and it's a principle that was adopted by the Supreme Court. But in the 4 decades since the Bivens case was decided, we have had a constant chipping away of the doctrine, and now we essentially have had an evisceration of the doctrine completely. In the 4 decades since Bivens, there were essentially 3 cases that were decided recognizing a right of action. The Davis v. Passman case recognized a private right of action to sue a member of Congress for sexual harassment in 1979. In the case of Carlson v. Green in 1980, we had a suit brought by a federal inmate for deprivation of medical care and his death as a result of asthma that went untreated. And then finally, in Farmer versus Brennan in 1994, we saw a preoperative transgender inmate being transferred to a federal facility, a maximum security penitentiary, putting her at great risk, and basically the court recognized a Bivens claim there. Since then, we have had 2 recent cases that have really changed the course of the law. Essentially, we have the Ziegler versus Abbasi case, that change in the baseline to which Gerald Torres referred. This involved the roundup of hundreds of Arab American and South Asian immigration detainees, and 6 of them sued because they had bones broken. They were detained incommunicado from between 3 and 6 months. They were subjected to sleep deprivation, lights on for 23 hours in tiny cells, and so forth. The court there, in a 4-2 decision with Justices Gorsuch, Sotomayor, and Kagan not participating in the decision, decided that the Bivens doctrine should be cabined very substantially. Essentially, the court established a 2-part test. First, if there is a new set of circumstances, there will be a consideration of the second factor, which will be whether there are special factors counseling hesitation before the judicial branch should get involved. With respect to the first, the court enumerated 7 different factors that constitute a new set of circumstances. And basically, any distinction between the previously recognized Bivens actions and the new case will result in a dismissal based on failure to state a claim. Those 7 considerations, those new factors, new circumstances, involve whether the rank of the officers involved is different, the constitutional right at issue is different, the generality or specificity of the individual action is different, the extent of judicial guidance as to how an officer should respond to the problem to be confronted is different, or the statutory or other legal mandate under which the officer was operating is different. And finally, the risk of disruptive intrusion by the judiciary into the functioning of other branches, or the presence of potential special factors that previous Bivens cases did not consider. So if there's a meaningful difference between previous Bivens cases and the case at hand, the court will not entertain that case and will consider whether there are also special factors counseling hesitation absent affirmative action by Congress, in the words of Bivens itself. In Bivens, the court considered that special factors counseling hesitation absent affirmative action by Congress meant that if Congress had not voiced any objection to a recognition of a Bivens action, the action should be entertained by the judicial branch. In the Hernandez versus Mesa case, that concept has been stood on its head. This is the case involving the 15-year-old boy who was running back and forth between Ciudad Juarez and El Paso, Texas, in the culvert separating the two countries. And he was playing a game with his friends, touching the fence and running back to the Mexican side. A Customs and Border Protection agent shot twice toward him. The first shot hit him in the face, killing him, and his estate, his parents, sued for damages to vindicate that deprivation of rights. Essentially, like in Ziegler versus Abazi, the court refused to recognize a private right of action to sue for damages, and essentially ruled that there were special factors counseling hesitation and new circumstances, thereby resulting in the dismissal of the suit. I raise all these questions.
Professor. Oh, excuse me. Yes, sir. I just want to give you your 2-minute warning.
Oh, thank you.
Sorry.
And that's very timely, because I'm shifting gears now to my proposed solution to these deprivations of rights that at this point don't have a remedy for damages. And essentially the primary proposal that I have made to my senators here in Oregon is a very simple fix. It is a suggestion of amending 42 USC section 1983 to essentially add 5 words to the statute. This is what I call the Federal Accountability Improving Responsibility Act. And it essentially expands section 1983 to include suits against federal actors. And so this would resolve the Bivens problem. The court has basically made it clear that until Congress acts, it's not going to recognize any more Bivens actions as implied rights. And so a statute is necessary. This does not solve the qualified immunity problem, which is being addressed in other legislation, but it is certainly a beginning to resolve the problem of not having a right of action to sue federal actors for deprivation of rights, causing injuries that should be redressable in the way of damages. And so I think that my time has probably expired. And so one of the last things I'll leave you with is the national security excuse that was used in both Ziegler versus Abazi and Hernandez versus Mesa. But I should point out that the court has said national security concerns must not become a talisman used to ward off inconvenient claims, a label used to cover a multitude of sins. And this is precisely what the Supreme Court has done with the Bivens line of cases as eviscerated by the cases of Ziegler versus Abazi and Hernandez versus Mesa. Thanks very much for your attention.
Thank you, Professor. We all really appreciate that great presentation. And with that, we'd like to transition over to Professor Hutchinson and take it away.
Hey, good afternoon, everyone. I too want to thank Professor Iglesias for organizing this event, and also to Dean Varona for sponsoring it. My presentation is going to be a little different from the others because instead of sort of going through doctrine and legal norms, I'm going to do more of a historical approach and also consider some sociology to try to give us a broader frame for discussing these issues. So the historical part, I want to take you all back in time, just a little over a century ago to 1918. This was a time of great change in the United States in terms of race, in terms of international relations, etc. One of the domestic issues involved the Great Migration, which is used to describe the departure of about 6 million Blacks from the South to areas of the upper Midwest and the Northeast from the period of 1916 to 1970. Why were they leaving? To escape some of the harsh Jim Crow policies in the South and also for economic opportunity. When they arrived, there was some more economic activity opportunity for them. There was also some more mobility and freedom, but they got a racist reception. The Chicago Tribune, for example, in a very infamous headline said that the rush of Negroes to the city starts health inquiry. It's actually an article about Philadelphia, but the Chicago Tribune's headline was so infamous that it becomes the defining article for that particular time period. The article warned of 2,000 Negro immigrants in the hospital in Philadelphia, 700 of whom were from tuberculosis. Now, part of this is alluding to the use of race and illness as a frame for denying equality and denying dignity to people of color. They also encountered housing discrimination, employment discrimination, racial violence, and a lot of that violence was either sanctioned by the state, namely police, and police were also complicit. What else is happening? In terms of global relations, World War I was coming to an end. There are many Blacks that served in the military, of course, in segregated units. And as in wars in the past, particularly the Civil War, this raised expectations of racial progress and more dignified treatment. In fact, the great sociologist, W.B. Du Bois, encouraged Blacks to participate in the military in order to demonstrate patriotism, a sort of respectability politics, believing that that would alleviate racial injustice. But this did not happen. Instead, Blacks returning from service were subject to racism, including racial violence, and this is a pattern that we've seen in wars, including World War II, later in history. At the same time, there was a president, very racist president. He campaigned on improving social conditions for all Americans, but it turned out that that was a lie. So Woodrow Wilson was a big supporter of Jim Crow. Not only that, he supported a very racist narrative called the Lost Cause, which blamed the failure of Reconstruction not on white supremacy, but on the North trying to force inept, unqualified Black leadership upon whites in the South. One of his first academic works was on this issue, and it was very steeped in the white supremacist narrative that Black ineptitude rather than white supremacy caused the end of Reconstruction. He also called the KKK a venerable institution. And once he assumed office, federal agencies, which had actually been more integrated than other governmental offices across the country, began to segregate. Very famously, the Department of Treasury, the Post Office, followed by other agencies, started having separate restrooms for races, separate water fountains, separate lunchrooms. Civil rights activists met with the president to discuss these issues, and he ejected them from the meeting because they complained. Right? Because they complained about the racist treatment, he said that they acted in an undignified fashion, and he threw them out of the White House. Using language that resembles the language in Plessy versus Ferguson, he said that segregation in the agencies was meant to avoid friction among Blacks and whites. It was It was a benign policy designed to make sure the blacks and whites were happy in the workplace. He also fired 15 out of 17 black supervisors who worked in the agencies and replaced them with whites. What else is happening? This World War I is coming to a conclusion. All right, and after World War I ended, the nation enters into a recession, just like there's a global recession at that time as well. This caused major economic tension among whites and people of color generally. There's it's a very worn path in history that economic anxiety fueled with racism causes a lot of social strife. So across US cities, racial violence was breaking out. There was social unrest across the nation, not only in the South, but also in Washington, DC, Chicago, and other northern cities. Police were often called to the scene, but instead of arresting whites who were engaging in mob violence, they actually arrested blacks who were the victims of the violence. And then a bigger parallel at the time, there was the Spanish flu, which many of you have heard on and has become a part of discourse now that COVID-19 has been a part of our existence for all of this year. The Spanish flu took over. There are 500 estimates, and the estimates vary, but estimates that 500 people worldwide were infected and 50 million were killed. And a lot of the same patterns that we see with respect to COVID existed then, in the sense that the poor and people of color were not only more vulnerable to the virus, but the medical treatment that they received was inferior, and they ended up suffering more in terms of death and economic losses. There was also a resurgence of lynching. I described some of the violence, but lynching occurred. It had been subsiding since Reconstruction, but it became much more apparent and aggressive during this time period. What does all of this mean? All right, so one thing I want to point out is that sociologists generally, and then there's a special brand of sociology called pandemic sociology or medical sociology, that looks at how social unrest happens. So during this time period that I was discussing, the summer of 1919 in particular, there are a lot of riots and protests and racial violence across the country, just as we're seeing right now. Sociologists who study violence and social unrest find that these factors are always apparent and sparking major unrest. That is economic anxiety, anxiety over one's existence in society. So for example, fear about your health, combined with historical patterns in those same areas. So historical racism, failure of the government to provide a response, being socially vulnerable across generations. All of these things are just a recipe for violence. Sometimes—
Excuse me, Professor.
Yeah.
You have 2 minutes left.
Okay, all right. So with all of that, I want to turn to the second part of the conversation, and obviously some things I'm leaving out we can talk about during Q&A. You can see the parallels. We have a lot of economic anxiety. People of color in particular are very fearful about their future in terms of work and in terms of their health. They're also disproportionately affected. They're forced to go to work because they're frontline employees. And again, we have the problem of policing and racial violence converging to create the situation that we see today. What I want to do is to turn to some lessons that we can glean, not only from this historical comparison, but more broadly. Criminal law is an element of social control generally, but it's really an element of racial control in the United States. All right, so just as the police were complicit in 1918 with the violence and how they're committing acts of violence today and being complicit with racial violence, in Wisconsin, we saw the infamous scene of the white male individual walking by cops with a gun, and after he had killed someone, the sheriff says, well, you know, if people had not been outside, they wouldn't have been killed. So we see those patterns throughout history, and I really recommend, I want to recommend some books before I close out. One is called The Forgotten Dead: Mob Violence Against Mexicans in the United States. Why am I mentioning that? Because the mob violence affected more than just African Americans, even though that's that particular group is more often discussed. And the other one is an aristocracy of color, race, and Reconstruction in California and the West. So we have criminal law being an element of racial subordination, but we also see that racism is resilient, right? It is resilient, it can morph, and it really requires sustained and continuous effort and resistance. And the final piece, which I know I'll run out of time on, is that psychologists or social psychologists today have actually written very convincingly that racism is embedded in punitive sentiment. What is punitive sentiment? A desire for punishment, a desire for harsh and aggressive policing. And just to rattle off a few stats, whites who overestimate the percentage of Blacks and Latinos involved in criminal activity. So they'll say, what percentage of Blacks do you think are involved in crime, or Latinos? The people who get the wildest incorrect answers, like they overestimate, they are the ones who are the most punitive. So when they sit down and have to sentence people, they really like high sentences and they like police aggression. Generally, whites are more punitive than people of color. And the biggest predictor of whites' punitive sentiment is racism. So looking at racial resentment scores, implicit racial bias, those are the individuals who are very committed to criminal law as a mechanism of social control. So what does that tell us? It really opens the door for a lot of conversations about remedies, the limitations on remedies, and what activists must do going forward. Because if punishment itself is racist, that seems to call for very fundamental transformation rather than reform. And I'm going to stop right there. Thank you so much.
No, thank you so much. Appreciate it. With that, we will go to Professor Jafuras. Professor, take it away whenever you're ready.
Thanks, David. Thank you. I want to echo the thanks, of course, to the University of Miami and Professor Iglesias and all of the wonderful co-sponsors for this event. I'm frankly honored and humbled to be a part of this important conversation, especially in light of the experts that I'm following on this panel and the others. As David mentioned, I teach at California Western School of Law, but prior to joining the faculty here in San Diego, I taught in the Civil Rights Clinic at the University of Denver. And then prior to that, and even concurrent to it, I was a civil rights litigator, primarily representing people who are incarcerated in seeking to challenge their conditions of confinement in federal court, predominantly under the 8th Amendment and the other rights protecting statutes. And I know that we have a vibrant and diverse audience here, from students to practitioners to academics, and our time is limited. So my remarks, I've tried to tailor them to be as relevant as possible to the communities that are here with us, and keep my remarks within the time that I have. So I'm going to focus on incarceration and detention, which is, of course, a form of policing. And like Professor Hutchinson, I'm going to, my presentation is a little bit different. Rather than diving deep into legal doctrine, I'm going to offer largely a descriptive component and provide an overview of what's going on in prisons and jails in this country over the past 6 months. And that is, what is the impact the pandemic has had on people and communities that are incarcerated? And as a bit of a foreshadow, the situation is unsurprisingly grim. And then in the last few minutes, I will touch on the law and specifically discuss some of the challenges that litigants and advocates have had in defending the rights of incarcerated people with respect to the conditions of their confinement as the pandemic rages on. And my overall message or theme for these remarks is one that Professor Torres eloquently highlighted during his keynote this morning, and that's this idea that the pandemic has acted as a metaphorical stagehand in pulling back the curtain on our system to expose the willingness of the state to sacrifice people and communities. And I also want to echo what Professor Hutchinson just said about the punitive nature of these elements of our society. And specifically with respect to American incarceration, I think the pandemic has only exposed, and perhaps exposed is not the most precise word, because scholars and impacted people and communities for decades have exposed the harshness and violence of incarceration, but rather the pandemic has highlighted and further contoured what the carceral system is in quote unquote normal times. And that is, of course, an inherently punitive system of confinement that disproportionately impacts people and communities of color, and from which the civil justice system and constitutional law, as the law is currently interpreted, is ill-constructed to provide protection. So let me start with a number, and that's the number is 121,217. That's the number as of last Tuesday, so now more than a week ago, of people who've contracted COVID-19 in prisons in this country. And that number is specific to prisons. So of course it doesn't count jails and immigration detention centers across the country. Once you add, of course, the total number of cases among those people in those populations, the number of COVID cases for incarcerated people rises significantly. And one more number, 1,107, and then that's the total number of deaths reported among prisoners, again, not counting jails and detention centers. And I'll be the first to admit, at first blush, that number may not shock some of us. The past 6 months might have numbed some of us to numbers like that, and after all, there we're now at 6.6 million cases among the general population in this country, and quickly approaching 200,000 deaths. But what's critical to keep in mind is that the COVID infection rate among incarcerated people is significantly higher than the infection rate among the general population. And studies to really drill down on those rates are very difficult to conduct due to inconsistent testing and inconsistent and sometimes non-existent reporting out of facilities. But there have been a few, and one study over the course of the summer showed that incarcerated people are at least 5.5 times more likely to contract the virus than non-incarcerated people. And just to put that in different terms, take 1,000 people in the general population, 587 of them will contract the virus and 29 will die. Take 1,000 people among the incarcerated population, 3,251 will get the virus and 39 will die. And with the majority of the 2.2 million people incarcerated in the country being people of color, the virus's tear through prisons and jails only multiplies the pandemic's burden on communities of color, which are disproportionately burdened, of course, not to the virus itself, but the many structural inequities that we've discussed and will continue to discuss today. So why the higher infection rate in prisons and jails? This is not difficult to see. I mean, people in prisons and jails live in close proximity to each other. Our prisons and jails are significantly overpopulated. They're unsanitary. Social distancing is impossible. Access to hygiene supplies and masks is often non-existent or significantly hindered. And access to reliable and adequate medical care is a longstanding problem. Moreover, we're seeing that prisons and jails disallow or significantly hinder the implementation and use of infection harm reduction controls. And this was particularly illustrated in a report from the California Office of Inspector General that was released just a couple of weeks ago, showing that the willingness of prison and jail administrators to seek assistance and expertise for infection control has varied from one jurisdiction to another, and is often an elemental feature in why some systems are experiencing worse outbreaks than others. So what have prisons and jails done in response to the pandemic? Well, some releases have happened, and we see this specifically with ICE detention numbers, and I caveat saying that ICE has reduced its detention numbers by saying that it has reduced its detention numbers from numbers that were higher than we had ever seen. So yes, the releases must happen, and decarceration is the only answer, I believe here, but we have to take those release numbers with a grain of salt. The majority of systems, however, the overwhelming response has been to amplify the punitiveness or the harshness of incarceration. Back in March, systems uniformly suspended visits, both legal and social, which meant that they immediately cut incarcerated people off from their families and advocates. They also implemented lockdowns, prohibiting incarcerated people from leaving their cells for the majority of the hours in the day. And they banned programming, so educational, religious, recreational programming. And essentially, under this guise of slowing or stopping the spread of the virus, prisons and jails have simply made incarceration harsher and, in my view, crueler than it already was. And they took these efforts while also resisting other efforts that are known to slow the virus's spread. So there was a lot of resistance, and still is, to varying degrees, to the use of hygiene and sanitation supplies, to the distribution of and requirement of masks and social distancing. And so this response back in the spring, of course, prompted a deluge of very valiant efforts by incarcerated litigants and civil rights advocates to get the courts involved in imposing proper harm reduction controls, imposing decarceration efforts, while also defending and promoting the rights of incarcerated people, specifically under the Eighth Amendment's right to be free from cruel and unusual punishment and its various corollaries within the pre-detention context. And
I'm sorry, Professor. Yeah, this is your 2-minute warning. Thank you.
Great, thanks. So many of these cases sought preliminary injunctions or other forms of emergency relief. And while some did have success at the district court level early on, as the months have worn on, we've seen circuit courts resoundingly turning any of those successes into functional, if not outright losses. And so this is where I just want to touch on the doctrine and then close with what I think what I want to provide as the takeaway to these remarks, which is that the underlying reasoning that the circuit courts engaged in for these losses is that the litigants had failed to show a likelihood of success on the merits. And that is, the courts did not see that the litigants, the plaintiffs, would ultimately be able to prove that a prison or jail's response to the pandemic amounted to a constitutional violation, and specifically with prisons to an Eighth Amendment violation. And so this, in effect, endorses that the system's response to the pandemic in prisons and jails is not cruel and unusual, and that is perhaps just punishment as usual. So my offer in response to this is that there's never been a better time to further highlight or bring to light the violence of incarceration in this country and the shortcomings of the Constitution, specifically the interpretation of the constitutional protection from cruel and unusual punishment that has emerged over the last decades. And Professor Torres again urged us all this morning to take this moment of exception to resist the urge to destabilize, and rather to insist that the proper response in an emergency is to reinforce the rule of law. And I generally agree, but I also want to echo what Professor Lopez said this morning about resistance lawyering, that when the law fails to protect and fails to uphold or promote rights protecting principles, the duty of resistance lawyers is to resist that law's implementation and entrenchment. And I think this is a moment to further expose the law's failures in policing here and take a critical look at civil rights doctrine and reimagine how the law might better protect during emergencies, because if it doesn't protect during emergencies, it's hard to see how it will protect during non-emergencies. Thank you.
Thank you so much. That was fantastic. So now we'll turn to Professor Jefferson. Professor, whenever you want to start, go ahead. Thank you.
Good afternoon. I'm going to attempt to share my screen very quickly. Okay, and what I'm going to talk about today, I'm going to give an argument or several reasons why we should consider releasing elderly prisoners, at least those who are in the federal system, in the wake of COVID-19. So the COVID-19 pandemic has opened our eyes to the myriad vulnerabilities in the prison healthcare system. While we have always known, it's always been clear to us that the delivery of health services to inmates lags far behind that available to the unincarcerated, the discordant degree of difference, if you will, has rather conspicuously resurfaced in the wake of COVID-19. We need only record the number of pandemic-related deaths of federal inmates to grasp that the prison healthcare system is profoundly ill-equipped to handle the needs of inmates during a public health crisis. And Professor Jefferis, in her remarks, alluded to some of this. The data is clear. For prisoners, it is not a matter of if, but when the virus shows up. So currently, prisoner infection rates outpace those of the general unincarcerated population by more than 150%. And prisoners are dying 4 times as often as prison staff who test positive. For elderly inmates, the results are even worse. So while COVID-19 affects people of all health profiles, its grip on the elderly is the most arresting. Researchers estimate that while the disease kills approximately 1.38% of people, fatality rates soar with age. For example, COVID-19 causes death in 0.03% of 40-year-olds and 1.25% of 50-year-olds, but results in death in 4% of those in their 60s, 8.6% of those in their 70s, and 13.4% of patients who are 80 years of age or older. This is due in large part to changes encountered during the twilight of the immune system. Older bodies are simply not as equipped to withstand the ravages of the virus as younger bodies. So though some effort has been exerted, federal prison officials failed to adequately protect the rights of the imprisoned elderly, which is highly unacceptable. It cannot be ignored that prison officials owe basic duties of care to the incarcerated, chief among them the responsibility to provide adequate health care. Prisons, by their very nature, are unable to care for an old and ailing population, and this glaring deficiency is rendered indisputable, if you will, by the novel coronavirus pandemic. For this reason, vulnerable inmates, especially the elderly, should be released to home confinement forthwith or someplace else. Anything else is profoundly inhumane and represents a colossal miscarriage of justice. So we'll start with the first idea, which is that prison systems generally are unable to care for an increasingly great population. So while all prisoners endure the indignities of incapacitation, the burden is far heavier for elderly inmates. Presently, elderly inmates comprise a disproportionate number of the inmate population residing at institutions, and they require higher levels of medical care, increased instances of outside care, and enhanced levels of catastrophic care. By their own admission, in their own words, prison systems are simply not equipped to handle the care of an increasingly greater prison population. For example, prisons' physical designs are not suited for the elderly. They often lack accommodations for the mobility impaired, as a small example. Also, elderly prisoners are often lodged in accommodations with younger, more robust prisoners, placing them at increased risk of victimization. Regular daily care also suffers, as elderly prisoners are often unable to participate in daily inmate life, including basic prisoner work duty. BOP institutions are struggling to maintain adequate levels of appropriately trained staff to manage a growing elderly inmate population. Prison simply is not intended to house inmates with any measure of special need, including the elderly. This is abundantly clear in the era of COVID-19. So prison systems also are unable to follow CDC directives to prevent community spread. The CDC makes it abundantly clear that the best way to prevent illness is to avoid being exposed to the virus, which is best accomplished by refraining from contact with other people. Health experts have identified those who are at risk of getting very sick as older adults and people of any age who have serious underlying medical conditions. For those in the most vulnerable category, social distancing is the best way to stay healthy. So while the rest of the country is focused on adhering to the CDC's guidelines, I mean, we ourselves are meeting in virtual space. You know, people are stockpiling masks, storing sanitizer, washing hands all day long, and steadily disinfecting. Prisoners aren't able to follow any of these critical directives. It is no secret that United States prisons are astoundingly overcrowded. Elderly prisoners specifically are not positioned to follow any of the CDC's advice, especially the most important thing, which is avoiding contact with others by staying home. Prisons then have become petri dishes, enabling profound community spread of coronavirus in closely quartered facilities. A further 45% of federal inmates suffer with chronic underlying conditions, and approximately 19% are considered elderly. Also, to bring to your attention, prison systems are simply unable to care for an increasingly ill population. So prison hospitals, as a general matter, are less resourced than hospitals in the general population and often lack basic equipment critical in stopping the flow of any disease, let alone the novel coronavirus. While the Supreme Court has recognized a right to correctional health care, that right has been established in a manner that's wholly inconsistent with general population healthcare delivery standards and models. In prison, the goals of medical care and correction clash to the detriment of patient prisoners. Medical care's mission is to diagnose, to comfort, and to cure, while prisons exist simply to confine and to punish. These two systems are utterly incompatible. Federal prison officials exercise full and complete control over inmates, and prison policies and procedures often intrude on care plans. Unlike in the general population, access to health services flows through prison guards, and medical orders are viewed as nuisances that interfere with correctionally necessary prisoner routines and schedules. For those that may face dying in prison, the situation is even more dire. The interests of the prison system and the prisoner patient are even more diametrically opposed at the end of the prisoner patient's life, as the prisoner patient's access to healthcare is controlled completely and totally by prison guards and limited by whether a guard chooses to allow the inmate to seek treatment. So you would think that our justice system would respond to all of this, but that is not the case. BOP's current posture on COVID-19 is startlingly narrow. It prioritizes prisoners with no disciplinary infractions who've been quarantined for 14 days and who either have served at least 50% of their sentence or have at least 18 months left to serve and have served 25% of their sentence. BOP initially transferred at the start of all this 566 inmates to home confinement. It moved another 900 following the enactment of the CARES Act, but several more vulnerable inmates remain dangerously in prison.
Excuse me, Professor Jefferson Bullock, you have 2 minutes left.
Thank you. The number of inmates allowed to serve the remainder of their sentence on home confinement represents only half of 1% of those in custody. While BOP remains irresponsibly static, elderly prisoners suffer. In actuality, the majority of these inmates should not even be in prison. For most of them, no punishment purpose is satisfied by their continued incarceration. And that is because for a lot of these elderly prisoners, they have simply aged out of crime. The aging out of crime theory is one of the most widely accepted premises in criminal research. Experts affirm that susceptibility to criminality is in many respects directly informed by age. The aging out of crime theory submits that self-control regulates criminality. The attraction to risky behaviors decreases as self-control develops with age. Thus, crime generally persists in youth and desists in older age. BOP conveniently forgets that many of this group pose no threat to public safety. They also disregard that for most, the sentence imposed was not death. So it's become abundantly clear in conclusion that the federal prison system is ill-equipped to protect vulnerable federal inmates during this pandemic. While the law currently allows for release to home confinement, federal prison officials have not drafted policies that support swift, safe release. As a result, scores of federal inmates are residing in a death trap. As in the case of implementing compassionate release and other early release policies, BOP is simply unwilling to abandon their role as jailers. If the DOJ is indeed committed to safeguarding the health and safety of vulnerable offenders, they should direct BOP to immediately transfer vulnerable prisoners to home incarceration or something like it. If they are not so committed, they should be rebuked and challenged in courts of law for converting these inmates' punishments to possible death sentences. Thank you.
Thank you so much. And now with that, we'll continue to Professor Skinner Thompson. Professor, whenever you're ready, feel free to start.
Well, thanks so much, David, for moderating, and thanks so much to Professor Iglesias for organizing this important event, and thanks as well to the amazing colleagues who've really helped educate me today. My comments are going to focus on the lessons we learned from the ongoing HIV epidemic regarding public health and civil rights, and try to bring those lessons to bear on the COVID epidemic and underscore a few examples of where I believe we're not following those lessons. To be clear, there are important differences between the two diseases stemming primarily from how transmission occurs, but the evolving legal response to HIV nevertheless offers important clues on how to win the fight against COVID. Public health emergencies, particularly those involving contagions, evoke a host of knee-jerk responses, often based on misconceptions. Fear and anxiety are, of course, understandable, but the antidote to that anxiety is education and communication regarding how a virus spreads, how it doesn't, and what can be done to prevent transmission and treat affliction. Unfortunately, as evidenced by President Trump's shameful and racist attempts to label the coronavirus Chinese, too often there is also a desire to blame, to penalize, and, as I'll discuss, to invade privacy. That impulse has resulted in punitive attempts to criminalize the transmission of the coronavirus that causes COVID and failure to adhere to public health recommendations. For example, the Federal Department of Justice declared that the federal anti-terrorism laws could be used to prosecute anyone who threatens or attempts to spread coronavirus. Similarly, early in the pandemic, New Jersey criminal laws were used to charge a man who allegedly threatened and coughed on a grocery store clerk. In Pennsylvania, a woman who was not believed to have had the coronavirus nevertheless faced charges for allegedly purposely coughing on exposed produce at a grocery store. And we're seeing punitive responses deployed at colleges and universities, as well as school starts, and we have police in effect serving as public health enforcers. Such efforts to criminalize contagion may satisfy the public's desire for retribution, but from a public health standpoint, they're often counterproductive. They may hasten rather than halt the spread of a disease. Widespread efforts to criminalize HIV demonstrate why criminalization backfires. The use of criminal laws to police and punish those who have engaged in activities that might have exposed others to a risk, sometimes a negligible risk, of HIV transmission persists widely in the United States. According to the Center for HIV Law and Policy, one of the leading organizations fighting the criminalization of HIV, about half of the states have HIV-specific criminal statutes. These statutes vary greatly, but many of them criminalize engaging in sexual conduct with another person without disclosing that one has HIV. And some criminalize sexual activities such as oral sex that pose low to no risk of transmission. States have also relied on broader criminal prohibitions like attempted homicide or assault laws to prosecute people who have allegedly exposed others to HIV. Importantly, the criminal law is frequently applied to HIV people who engage in sexual conduct even when no actual transmission of HIV occurs. So whether pursued under general criminal law or HIV-specific statutes, the criminalization of HIV transmission has negative public health impacts. And the same will probably hold true for efforts to penalize coronavirus transmission. First, criminalization discourages people from getting tested. Most criminal laws have some form of mens rea or knowledge requirement. So if a person doesn't know they have HIV or COVID positive, they may not be successfully prosecuted for potential transmission. This disincentivizes testing because if you do not know your status, you are less likely to be prosecuted for knowing transmission. Second, the criminal laws may be used to prosecute people who are engaged in activities that pose a low risk of transmission. For example, if a person with HIV uses a condom or has an undetectable viral load, then the risk of transmission via sexual intercourse is very small. This is a concept known as U equals U, or undetectable equals untransmittable. And HIV criminal laws have often fail to consider that today, through the use of a pre-exposure prophylaxis or PrEP, assuming you have access to healthcare, which is a big assumption, all parties to a consensual sexual encounter can protect themselves from HIV transmission. Similarly, prosecuting someone for coughing or failing to physically distance themselves, even if they do not have coronavirus, perpetuates misinformation regarding how the virus is transmitted and adds to social paranoia rather than societal preparation. To be clear, everyone should, to the extent possible, physically distance and wear masks to protect themselves and others. And because they may have the virus and not know it, a concept in effect known as universal precautions, assume everybody has the virus and take measures to prevent it. And when you assume that everybody has it, then then you don't, then stigmatizing someone who may actually have it becomes unnecessary. And the best way to get people to take those measures is trust and education, not penalization, as I'll discuss in more detail in a moment. Third, there's scant evidence that criminalizing sexual conduct when someone is HIV positive actually deters people living with HIV from engaging in that conduct in the first instance. That is, these criminal laws don't appear to deter HIV positive individuals from having sex. The same is likely to hold true for efforts to criminalize COVID. And I think we're seeing that. Criminalizing certain behavior related to safely exposing other to COVID may have marginal influence on individual behavior, but the more effective method of changing the public's behavior is to educate people on how to protect themselves and others, which can also help build trust between the government and society. Now, unfortunately, because of the lack of trust between the people, particularly marginalized communities, and the government due to misinformation coming from the federal government and violence against people of color, establishing that education has been made more difficult. And we've missed an opportunity for a collective call to social action. Instead, our federal government has further sowed division. Be that as it may, we, those of us involved in public health education continue to need to try to build that trust and get the message out there. Moreover, and as several of my colleagues really explained in detail, efforts to criminalize coronavirus will undermine efforts to protect incarcerated populations from exposure and outbreaks by potentially sending people living with coronavirus into jails and prisons where distancing is impossible. Fourth, as with many criminal laws, HIV criminal laws disproportionately impact people already at the margins of society and subject to over-policing, including sex workers and people of color. There is no reason to believe that criminalization of COVID will not have the same effects. Disadvantaged communities lack ready access to healthcare and may have jobs or living quarters that limit their ability to self-isolate or quarantine, and they will bear the brunt of the coronavirus in the first instance, and then be most vulnerable to charges of criminal transmissions. For all these reasons, the National HIV/AIDS Strategy, first released by the Obama administration in 2010, called on states to examine whether or not HIV criminalization made sense. And I think that we need to be asking that same question with regard to coronavirus. Finally,
Professor, you have 2 minutes left.
Perfect, thank you. As alluded, but I'd like to fully underscore now, privacy and confidentiality are not the enemy of public health, but it's good friend. Conversely, stigma is the enemy of public health. In the HIV context, pursuant to the federal Ryan-White Act, all states now require that positive test results be reported to the state public health department, including the patient's name, so-called names-based reporting. And this is so that that individual can be counseled on treatment and prevention. But that information is largely confidential, and the data is passed on to the CDC, but the identifying information is removed. As a final form of surveillance, certain states require sexual or needle partner notification, e.g. a form of contact tracing, some encouragement. That is, while disease surveillance and contact tracing is undoubtedly an important public health tool, as with HIV, we should try to circumscribe identities of people with COVID to the extent possible to avoid stigma and focus on activities that are capable of actually transmitting the virus. That is, not every contact is medically significant, and not everybody that comes in contact with someone with COVID needs to be contacted. You need to know how meaningful the contact was in terms of likelihood of transmission. I should add that there have been a few instances where law enforcement have pulled up someone's identification and seen on the database that they have a positive test result, suggesting that public health info is being shared with law enforcement, is not being cabined and kept confidential to public health entities. This does not encourage testing or more information gathering. It serves as a deterrent and can lead to poor public health outcomes. So in short, as we begin to mitigate the harms caused by coronavirus, I believe that we should bear the lessons of the ongoing HIV the epidemic in mind and not risk to criminalize and thereby stigmatize the disease. Thank you.
Thank you so much. That was great. Now, with our remaining time, we're going to ask a question from the student body. So here, I'll start it right now. Whoever wants to take a crack at it can go ahead. So given the recent shift to the online court system, I'm curious to know if and how you think the system will have a disparate impact on indigent minority communities and their access to justice under the Due Process Clause, specifically because low-income minority communities have limited or restricted access to the means by which jury trials are now conducted virtually via Zoom. How can the law guarantee that indigent defendants are tried by a representative jury of their peers?
I mean, go ahead, Darren.
So my expertise is not on courts and the litigation process, but there have been a lot of issues that have come up, not necessarily that I've heard about on the trial level, but just this whole process of everything being remote and has really slowed down the system a lot. So coming out of a lot of big cities in particular where the courts are already overburdened, you have situations where people are sort of in pretrial detention for longer periods of time. And I know there's been some litigation over that. And as we already know, statistically, low-income individuals, people of color, are going to be the ones who are in the system in terms of being arrested. But after that, they're the ones who are going to be either required to pay a cash bail or will be remanded and won't have the ability to get out at all. So the slowing down of the system certainly has affected the pretrial level. And I suspect in terms of the trial level, those inequalities have already been there. So if you're a wealthier person, you can have a lawyer who can hire jury experts to help you with all manner of jury selection. So that's there. But those could be augmented in terms of COVID because of the remote nature and just more burdens on the litigation process generally. So it's definitely something I think we need to continue thinking about and looking at.
Yeah, I would just add or underscore, I think embedded in the question is an assumption that our jury system works fairly in a pre-remote world, and I think that's probably an inaccurate assumption. That the system is, as Darren, I think rightly emphasized, is tilted against marginalized communities, and so maybe I don't know, and this is, I think. Gesture to in a lot of people's comments, including going back to the previous panel and Professor Lopez's comments on resistance lawyering, which is that maybe we're seeing a moment where the system falls under its own weight. I don't know that. I don't think I'm that optimistic, but I do think that we need to grab the opportunities that are presented by the tragedy of the pandemic to underscore every structural inequality we can. And I think this is a...
Great, thank you. And then as a quick follow-up to that initial question, the student asked, what role does the federal government play in regulating procedure in state court under the new virtual court system, if any role at all?
So state courts are pretty autonomous. I mean, Congress is authorized by the Constitution to provide regulations for courts of the United States, but as per the 10th Amendment, states retain the power to create rules governing the state court systems. Now, there's always this caveat of due process. So regardless of whether Congress has acted, the Due Process Clause of the 14th Amendment applies to state action in every form, including by judges. So, for example, the process of people languishing in pretrial detention, unless they've waived some type of right, that could give rise to litigation. Some of the problems that other panelists talked about earlier, if you were thinking about some type of equal protection clause argument, those would be far more difficult because of the court's requirement of discriminatory intent. But I could see some of these cases giving rise to due process arguments. Either in the first ground would be in the state court system itself, but it failing that, also appealing in the federal system.
Just a brief addition to that, there have been efforts by the Trump administration to arrest people for immigration violations in courthouses, state courthouses. And that's a real problem, and that's in litigation. It's, I think, the view of most commentators at this point that that's inconsistent with the administration of justice through the state system. But that remains to be seen definitively.
Well, thank all of you. Thank you for giving us your time and expertise. With that, I'd like to give you, as was done earlier, a virtual applause. And with that, my panel's over, and we'll be transitioning to panel 3, moderated by Emily Sanchez.
Good afternoon, everyone. My name is Emily Sanchez, and I am president of Miami Law's Health Law Association. I will be the moderator for this panel. This panel will focus on the way the pandemic has exacerbated civil rights issues arising from inequality and unequal treatment in employment, housing, education, and access to justice, focusing specifically on its exacerbation of vulnerabilities based on race, disability, age, gender, class, and occupations cast as essential. Our panelists are Sean M. Scott. Sean Scott was appointed President and Dean of California Western School of Law in 2020. Prior to her appointment, Dean Scott served as a member of the faculty of Loyola Law School. She is a graduate of Smith College and New York University School of Law. While at NYU, she was a recipient of the Arthur G. Hayes Civil Liberties Fellowship and was a chair of the Black Law Students Association. Prior to joining the Loyola School of Law faculty, she was an associate at the Los Angeles-based firm of Minnette, Phelps and Phillips. Next, we have Madeline Plasencia. Professor Madeline Plasencia earned tenure in 2003 at the University of Tulsa College of Law. She graduated cum laude with highest honors in French literature from Cornell University and earned her Juris Doctorate from the University of Pennsylvania School of Law with honors. While in law school, she was the managing editor of the Comparative Labor Law Journal. Professor Plasencia has been a friend of ours for many years, participating in and co-organizing conferences at Miami Law, including the 2007 Law Review Symposium entitled Article 2, The Uses and Abuses of Executive Power, as well as the 2005 conference entitled Surviving the Miami Model, Civil Liberties, Independent Media, and the Role of Universities in Preserving Freedom of Expression. Our next panelist is Leah Epperson. Leah Epperson is professor of law at American University, Washington College of Law, is a nationally recognized expert in the areas of civil rights, constitutional law, and education policy. Her scholarship centers on the constitutional dialogue between federal courts and the political branches and its implications for educational equity. Her scholarship, published in leading journals, also explores the role of public schools, colleges, and universities in creating equal opportunity. From 2014 to 2018, Epperson served as Senior Associate Dean for Faculty and Academic Affairs at the law school. In 2018, she was awarded an Institute for Advanced Studies Fellowship with the Collegium de Lyon in Lyon, France, working with scholars at the University of Lyon and from around the world on issues of constitutional law, freedom of expression, and equality. Our next panelist is David Lopez. David Lopez joined Rutgers Law School as co-dean in August 2018 and was the longest serving general counsel of the U.S. Equal Employment Opportunity Commission. Dean Lopez was twice nominated to help the position by Barack Obama and confirmed by the United States Senate. He most recently worked as a partner at Oden and Golden in Washington, D.C., and is a nationally recognized expert in civil rights and employment law. He earned his undergraduate degree magna cum laude from Arizona State University and his JD from Harvard Law School, where he has lectured. Our last panelist is Leanne Frith. Leanne Frith is a dean of the Career and Professional Development at Mitchell Hamlin School of Law. She previously practiced business law, employment law, and commercial and employment litigation at Lawrie & Lawrie, where she helped clients with matters involving business formation and management, discrimination, sexual harassment, whistleblowing, breach of contract, non-competes, wage and hour violations, unemployment hearings, and other claims. As a moderator, I will be keeping time for our esteemed panelists. Each will have 10 minutes to speak. When each panelist has 2 minutes left, I will turn on my microphone and indicate to the speaker, you have 2 minutes to wrap up. At that 10-minute mark, I will say time's up. And afterwards, after each speaker has spoken, we will have a time for question and answer period. And hopefully that will be a 15-minute period of time for students to ask questions. Thank you all for being here today. We are excited to hear from you. Now, I'm going to hand it over to Professor Scott to get us started.
Well, thank you so much for inviting me. Can you all hear me? Thumbs up. It's really an honor to be attending. This is a great panel of folks. A shout out both to Maddie and to Lisa for putting this together and for inviting me. So a couple of things that I have been concerned about in the past couple of years really has been on the diversification of the legal profession and in particular the academy. I think this is so critically important as our democracy, from my perspective, is under threat. This is fundamentally what lawyers do, right? We ensure that we as a country keep our promises, despite the fact that those promises have been repeatedly broken. It is our obligation to point that out and to hold our nation accountable. Those of us who are of color and from marginalized communities have much at stake in the maintenance of this democracy, and thus we need lawyers and law faculty. So, and when I think about the impact that COVID has on the diversification of the profession and the academy, I have two countervailing theories. Only one of them will turn out to be true. I think that COVID is going to exacerbate the digital divide so severely from elementary to grad school that is going to greatly depress the number of students of color attending college and then moving on to grad school, including law school. Second countervailing hypothesis, that the extraordinary power of the anti-racist movement, nationally, even globally, will spark an uptick in the numbers of students of color attending and graduating law school. Only one of these is going to be true. Time will tell. I have my thoughts, which I'll share with you kind of at the end of my comments. The digital divide. COVID has exacerbated the digital divide between those with resources and those without. Access to hardware, right? Computers, a laptop, on which students can attend school and access information educationally. Parents who may be unable to assist children who are working, doing their schoolwork from home. Access to high-speed internet. You know, we have everybody online with multiple devices. And in order to access schoolwork, you need high-speed internet that costs money. Access to a quiet place to study. Many people of color live in multi-generational households. Finding a place to do work is challenging. Libraries are closed. School is closed. Coffee shops are largely closed. We face loss of income. we face homelessness, we face food insecurity, all of which I think it obviously reverberates across society, but in terms of access to education and preparation for graduate school, it's going to hit marginalized communities, communities of color the hardest. So what does that mean in terms of getting folks, marginalized people, to law school and on to the academy or to the profession more broadly? I actually do think it's going to be pretty devastating. COVID has caused and will cause contraction of the economy. I think it's going to lead to a recession. There will be fewer jobs. There are going to be fewer law jobs. There are going to be fewer law faculty jobs. And we saw this before with the 2008 recession. The contraction of the economy had a huge impact on law schools, enrollment, and thus hiring. What that meant, one of the consequences of that was the hyper-credentialing of law faculty. So because jobs were scarce, law schools upped their credentials for faculty hiring. That continues to reverberate today. So really quickly, this Sarah Lofsky and this labor of love continues to collate information on entry-level tenure track hiring. 2019-2020 cycle, 91% of entry-level tenure track hiring hires had either a VAP or a PhD, 91%. 32% of faculty hired had both. Having to accrue these credentials in order to have a viable opportunity is really challenging for students of color. Again, brief statistics, 52% of African American law students graduated with over $150,000 worth of student loans. 31% of Latinx law students graduated with over $150,000 in student loan debt. To ask them to take another 2 years to take a VAP, to take another 5 years to invest in a PhD, when they carry these kinds of financial burdens, seems to me to be unrealistic. If we want to talk briefly about what PhDs look like, we have about 5%, this is all, I can give you the data sources for all of this, but we have, as of 2018, 6.5% of PhDs granted were granted to Latinx folks, 5% granted to African Americans. If you are looking for somebody with a PhD who is a person of color, you're looking for a needle in a haystack. Our opportunities are shrinking. COVID, I think, is going to do the same thing. That's my prediction, right? I think that the shrinking of the job market, the shrinking of access to education is going to shrink the number of students of color and other marginalized people going into law school, other graduate schools as well, but to law schools and thus onto the profession and onto the academy. I think we are going to see hyper credentialing in the next couple of years. Initial data indicate that that's going to be true. I think anecdotally, we have maybe 32 schools out of 200 or so law schools actively hiring this year. That's 3-2. Because COVID has meant for universities uncertain budgets, lack of income from room and board. That means that law schools aren't getting money from their universities. And in fact, law schools, even though we have kind of attained some equilibrium, are under demands from our universities to send money back to the university. We're not hiring, to say the very least. And so again, I think we see this great contraction in the marketplace, and that's going to have an impact on the demographics of our profession. I think it's going to be negative. The push for anti-racist, the anti-racist push for diversity, equity, and inclusion is a countervailing force. I think that even more so than in the past, we are all feeling the pressure to diversify our faculties.
2 minutes.
But we as faculty have not engaged critically with the hyper-credentialing of candidates. And so rather than kind of abandoning or really thinking critically about the credentials, I think we are just going to use them, and I think we're going to reinforce exclusion and not inclusion. And with that happy prediction, I turn it over to my fellow panelists. Thank you.
Great. And our next panelist is Madeline Placencia.
First, I would like to thank Professor Elizabeth Iglesias for organizing this remarkable conference, and Dean Tony Varona for that beautiful introduction, and the entire Miami Law team for hosting this event. I'd also like to thank and am honored to appear with my panel mates and other speakers to learn their insights in this critical time. I'm going to talk about disability law in the context of COVID-19, particularly as it relates to people who are at a higher risk of experiencing severe symptoms from the infection. In dealing with this pandemic, businesses, schools, and other covered entities have to navigate and manage at least 3 different categories of people who are congregating. One, there are those who act as if there's no pandemic at all. They simply do not care if they are contagious and insist upon not complying with safety precautions, mask wearing and social distancing. Second, there are people who have medical conditions that make them especially vulnerable and at high risk for severe symptoms associated with the infection. Third, there are people who have already contracted COVID-19 and are currently experiencing symptoms or have recovered from COVID. The point of my presentation is to discuss law that would protect the second and third groups, especially against the first group. That is, I argue that there's ample, if not obvious, civil rights law available in a pandemic to protect people with a prior medical condition or disability, and to protect those who have become physically impaired because of a prior or current COVID-19 infection. So in part 1, I identify the special pandemic-focused problems that arise when these groups interact. In part 2 of my presentation, I'm going to talk about U.S. Supreme Court jurisprudence addressing what I call contagion law. In part 3, I discuss the global and local statistics related to the spread of the virus, especially as these relate to the housing needs and demographics right here in my hometown, Miami. In part 4, I conclude that state, quote, contagion law and federal disability law have been understood to work together to keep everyone safe, especially during a pandemic. So let's talk about lying during a pandemic. Perhaps as a matter of American heritage or societal memory, people today suffering from COVID-19 are hiding or evading reporting symptoms or test results when accessing facilities. A recent study conducted by Brock University in Canada found that the majority of people living in the United States who believe that they have contracted the novel coronavirus have lied about their social distancing practices, their test results, and their symptoms. Coupled with this finding, consider the fact that there's an alternative reality being projected by people professing that, quote, COVID is a hoax invented to destroy the United States. As the Supreme Court observed 33 years ago in School Board of Nassau County versus R-Line, quote, few aspects of a disability give rise to the same level of public fear and misapprehension as contagiousness. Even those who suffer or have recovered from such non-infectious diseases as epilepsy or cancer have faced discrimination based on the irrational fear that they might be contagious. The Rehabilitation Act is carefully structured to replace such reflexive reactions to actual or perceived disabilities with actions based on reasoned and medically sound judgments. The definition of a disabled individual is broad, as the Supreme Court. The fact that some persons who have contagious diseases may pose a serious health threat to others under certain circumstances does not justify excluding them from coverage of the Act. All persons with actual or perceived contagious diseases. Such exclusion would mean that those accused of being contagious would never have the opportunity to have their condition evaluated in light of medical evidence and a determination made as to whether they were otherwise qualified. Rather, they would be vulnerable to discrimination on the basis of mythology, precisely the type of injury Congress sought to prevent. End quote. In our line, the court held that a school board's decision to fire a teacher living with tuberculosis violated the Rehabilitation Act. Justice Kennedy explained the stigma and irrational shunning endured by people who are, quote, afflicted with a contagious disease. Responding to concerns raised by dissenting Justices Rehnquist and Scalia, Justice Kennedy noted that coverage under the disability statute would not, quote, extend beyond manageable bounds because, quote, a person who poses a significant risk of communicating an infectious disease to others in the workplace will not be otherwise qualified for his or her job if reasonable accommodation will not eliminate that risk. The act would not require, for example, a school board to place a teacher with active contagious tuberculosis in a classroom with elementary school children, end quote. A decade later, in Abbott versus Bragdon, Justice Ginsburg noted that an asymptomatic viral infection, HIV, quote, pervades life's choices, education, employment, family, and financial undertakings, end quote. And similar to COVID-19, Justice Ginsburg underscored that, quote, the disease affects the need for and the ability to obtain healthcare because of the reaction of others to the impairment. So, is COVID-19 a disability under the Americans with Disabilities Act? The statutory and regulatory definitions of the ADA would be met when the infection is, quote, a physical or mental impairment that substantially limits major life activities or is so perceived. Body. The Washington Post reports that doctors keep discovering new ways the coronavirus attacks the body. It may very well be many years before it's understood how COVID-19 damages organs, how medications, genetics, diets, lifestyles, and distancing impact its course. Perception. The CDC has specifically identified groups of people who may experience stigma during the COVID-19 pandemic as those who are, quote, people who tested positive for COVID-19, have recovered from being sick with COVID-19, or were released from COVID-19 quarantine, end quote. On the other hand, considering possible direct threat risks of the spread of the virus in COVID-related litigation, the court might demand an individualized assessment for each individual who has contracted COVID to be determined under the Act. Justices Rehnquist and Scalia, in the R-line dissent 33 years ago, made much of the fact that both on a federal and state level, regulation in the area of contagious disease has a long history. Quote, the coverage of state statutes regulating contagious disease is broad, addressing, among other things, quarantines, compulsory immunization, certification, and medical testing requirements. There is no doubt there is an obligation to protect others from a very serious life-threatening viral infection, end quote, said the court in the Southern District of New York recently in Doe versus Deer Mountain Day Camp, citing our line. To focus in on the challenge of navigating between disability protection and contagion containment, let's talk about the spread of COVID-19. Slide, please. Can you advance the slide, please? Thank you. The spread of COVID-19 throughout the world paints this picture that you see here. On the world stage, yes?
2 minutes.
Thank you. On the world stage, the United States, as you can see, is number one. Slide, please. Within the United States, California leads, then Texas, then Florida. Slide, please. The Dakotas, as you can see, are an active outbreak risk. Vermont is the only state on track to contain COVID, the little green sliver there. Slide, please. 45% of Miami homes are multifamily homes. That means that nearly half of the county's population are squeezed into structures that account for only 11% of the total of building types. Slide, please. 8 out of 10 Miamians have at least one member diagnosed with high blood pressure. Slide, please. Studies show that Miami is predominantly elderly, female, uninsured, poor, and minority. And the CDC has enumerated a long list of conditions that are likely to increase the risk of severe COVID, regardless of age: cancer, obesity, heart conditions, sickle cell disease, diabetes, asthma, hypertension, HIV, pregnancy, and smoking. Slide, please. Just yesterday, the CDC published a report finding that Black and Latinx children die from coronavirus more often than white children. Slide, please. Suffering from the same structural disability as older adults, these children suffer from lung problems, obesity, and heart problems. So, based on the R-line decision itself, and based on Rehnquist's dissent in R-line, it would be a difficult road to hoe, arguing that the Miami maskless may privilege their disregard of the pandemic over the state's authority to protect the vulnerable against contagious diseases. Thank you.
Thank you, Professor. And now we will have our next panelist, Leah Epperson.
Hi, good afternoon. Well, thank you very much to Professor Iglesias, to Dean Varona, for having me as a part of the conference, and also as, I guess, a part of our work with the AALS Civil Rights section, on which I serve. I am going to be talking about pandemic education and the role that COVID-19 plays in affecting racial inequities in educational opportunity. So interestingly, this, I think, flows rather naturally from what we've been talking about and from Dean Scott's fantastic presentation about the kind of dual issues facing legal academia and higher education. It's very much a part of what you see at the K-12 level, which is more of what I'm talking about right now. And similar to what Professor Plasencia was talking about as well, I want to highlight some of the existing inequalities that we see, inequalities in US education, and how kids of color are disproportionately harmed by the existing pandemic of COVID-19, what some of those short-term and long-term effects are in educational access, and what we might be looking to do to address that, both short and long-term. So let's see, I've got this. I can advance my slide. Yeah, okay. I'm starting with a quote because as I teach and write around constitutional law and education law, despite the fact that our US Constitution has in many ways been very unhelpful with respect to addressing educational inequities, we do have this language that I think when we think about our larger constitutional and democratic values should guide us. The notion that comes from Brown that education is the very foundation of good citizenship, that in the field of public education, the doctrine of separate but equal has no place, and that separate educational facilities are inherently unequal. I think this is an important piece to remember as we talk in general about racial inequalities in educational opportunity, and specifically what things like COVID-19 are doing to access to education and educational opportunity. And similarly, in the oral argument for Cooper v. Aaron a few years later, Supreme Court Justice, then later Supreme Court Justice, but then lawyer for the NAACP Legal Defense Fund, Thurgood Marshall said, education is not the teaching of the 3 R's. Education is the teaching of the overall citizenship, to learn to live together with fellow citizens. And so that's very much a part of what is at stake when we talk about disparities in educational opportunity and what the long-term effects of that may be. Okay, as was just mentioned, we have this information and data from the most recent CDC report that just came out that does really emphasize what many of us have already come to know in some of our research, that COVID-19 is more deadly for children of color. And so despite the fact that kids of color only make up about 41% of the population, the CDC reports that 78% of the children killed by COVID-19 are Black, Latinx, and American Indian Alaskan Native children. 78%. So in a very straightforward way, we see how COVID-19 is disproportionately negatively affecting children of color and their ability to live in this country and to grow and to learn. And as has been reported in some of the other discussions, the root causes of COVID-related child deaths stem from environmental factors that are directly linked to structural racism. So these are things like food insecurity, housing insecurity, overcrowding in neighborhoods, lack of access to healthcare, and that lack of access is due to a host of factors that include things like access to childcare, transportation, lack of insurance, or lack of access to sick leave for working parents. These root causes highlight the continuing reality of racial segregation in the United States. And it helps to understand some of the challenges of segregated education, because these are inextricably linked. These types of root causes of COVID-related child deaths and actually the effects that they have on educational access. And in addition, I would just, part of what this shows is these types of factors are the very factors that impede learning, that affect the whole child, you know, soup to nuts, and tend to exacerbate already existing opportunity gaps, as we'll see. So interestingly, in the United States, we are actually now at a point where we have no racial majority enrolled in US schools today. So there's no one racial group that is a majority of US schools, and yet schools are deeply racially segregated. So as the slide shows, 80% of Latinx students attend segregated schools. 43% attend intensely segregated schools. Those are ones where only up to 10% of the rest of the student body would be white. 74% of Black students attend segregated schools, and 38% attend intensely segregated schools. And we know that these types of disparities are related to a host of factors. You cannot unconnect the longstanding intractable residential segregation that exists in the United States. And this plays an equally pernicious role in what we see in terms of schools. And it also has the effect of what we call double segregation, which is an intersection of racial and ethnic segregation with socioeconomic segregation, a high concentration of poverty. So on average, Black and Latinx students attend schools with much more poverty than their white peers. And these numbers are growing. So lest we think that we are had some period of time where we might have had a utopia, a racial utopia with respect to schools, we do not. That's also perhaps in part why I have behind me the Norman Rockwell famous painting of the problem we all live with, which is school segregation. So these statistics, they have vast implications. They have implications for employment. They have implications for health, for life opportunities. And we now, in the decades since Brown versus Board of Education, with many longitudinal studies and with a lot of work by sociologists and social psychologists, we have data that talks about what racially segregated schools with high concentrations of poverty have. We know they have fewer resources. We know those are the schools with less experienced and less credentialed teachers. We also know that students in those schools have limited access to advancement networks, and these all contribute to higher disparities in terms of educational opportunity, high school graduation rates, college attendance, employment, life, health opportunities. And conversely, evidence demonstrates that diverse schools are the ones that have significant advantages that include things like higher graduation rates, college attendance, also things like improved critical thinking skills, and studies show greater civic participation for those students. These are the students who grow up to be more likely to be engaged in democratic systems, to be involved in their communities, and the like. So it does have a host of positive outcomes. So what does this mean today? So here we are in September of 2020, in this incredible moment of this viral pandemic. And Dean Scott spoke about this a bit when she mentioned that she has a hypothesis about the exacerbation of disparities with respect to the digital divide. And that is absolutely true. We know that to be the case. So students in the poorest school districts are interestingly the ones most likely to be engaged in fully remote learning. In other words, they're in the schools that are the least likely to be open right now in the midst of COVID-19. And we also know that low-income students of color are less likely to have the tools necessary to learn in those schools. So they're the ones who are less likely to have access to home internet or to have a computer, which is necessary to be able to be educated in the midst of COVID-19. And so this is true if you see these slides for kids that are in households of less than 100,000. And also you see the very high rates of lack of computer access and internet access for American Indian Native Alaskan students, for Black and for Hispanic students. Now, at the same time this is happening, I want to actually highlight the other pandemic that has been alluded to here in our discussions, and that is the pandemic of racist violence in the United States. This plays out in a very important domain in education in a host of ways, which is that we know there is racially discriminatory use of school discipline policies in schools across the country, that these affect life opportunities, particularly for Black and Latinx students, that Black students are 3 times as likely to be suspended or expelled as white students, Latinx students 1.5 times as likely. And right now we have a police state in public schools. We have at least 19,000 police officers stationed in public schools around the country. They are disproportionately placed in schools with Black and Latinx students. And these are also the students who are at this moment in time, in 2020, experiencing higher rates of bullying, of racially motivated incidents of bias and hate crimes in schools. And yet, they are also the students who are more likely to be at a school that has all this security. I'm sorry, is it time?
Yes.
Okay, more likely to have security and not to have mental health providers. So again, these are things that affect the life opportunities of these students. So I would just end by saying there are long-term effects to what we're seeing today. We will see these effects for many years to come. Increased high school dropout rates, social and emotional disruption, clear cuts to K-12 education, which disproportionately affect low-income and Black and Latinx students, and long-term economic devastation. So for students in these schools, some of the things we need to look to are the role of state constitutional mandates that guarantee educational equality or adequacy. We need to look at funding, and there are lawsuits going on right now about this against the Department of Education with respect to the allocation of funding under the CARES Act. But it has to be about how the funds are equitably distributed to pay for support services for students in districts that are most in need. And a redirecting of funds outside of things like school resource and police officers to provide for support, social and mental health services, and using the federal government as a space for the provision of guidance and best practices to districts. Thank you.
Thank you, Professor. And now we have our next panelist, David Lopez.
Thank you very much. It's a real honor to be here. Thank you to the University of Miami. Thank you, Professor Iglesias, Dean Varona, the Hispanic National Bar Association for sponsoring this very important symposium. I know that I'm going to see some of you in an hour at the HNBA Young Lawyers Division, which we're sponsoring. I want to really springboard a lot off of what some of the previous panelists have talked about. President Scott, professors, Professors Epperson, excuse me, and really examine sort of the macro view of where we are. And what I want to do is I want to really use the mask as sort of a metaphor for some of the choices we face about revitalizing our democracy, because I think that what the bottom line with this conference is that we are facing an enormous amount of inequality before the pandemic, and that the pandemic has actually exacerbated it on several different levels. And what we're seeing is really an unraveling, I think, of the social contract. The whole social contract that our governmental institutions are guided by the consent of the governed. And we're facing tremendous choices right now. So I think many of you probably took philosophy classes or ethics classes. And in those classes, they often gave you a hypothetical on the lifeboat in terms of how you make ethical decisions or the types of ethical decisions you would make. We're actually living this in real time. We're living in real time the reality of lifeboat ethics in our country. Because what we see is that communities that have been had been traditionally marginalized, both economically and electorally, are really suffering the brunt of COVID, are suffering the brunt of the nearly 200,000 deaths. As you know, as has been discussed, the broadest impact of COVID has been on communities of color, on American Indians, on African Americans, on the Latinx community. And this is really a reflection of historical housing segregation, of the absence of opportunity, absence of adequate health care. It's also a reflection of the types of jobs that communities of color are facing. We tend to be in many of the essential worker jobs, transit, farm workers, meat packing. So these are all structural issues, right? And as you start to break down the COVID mortality rate, you start to see large numbers of homeless who have died of COVID, the incarcerated, you know, where we have some of the largest COVID clusters in the country, in prisons around the country, and essential workers who are working as farm workers or as meat packers. And so what you're talking about are communities that have traditionally been excluded economically, but also excluded electorally. And the response that we've seen is that a good portion of the population is taking these nameless, these nameless populations and allowing them and turning their backs indifferently on the fact that they're dying in record numbers. And so you hear reactions such as oh, they had comorbid conditions, they would have died anyway, or they didn't really die, the numbers are inflated, and similar types of reactions. And what this really reflects is an unraveling of the social contract. This reflects a turning the back on our neighbors, on other members of the polity, right? In a way that has enormous consequences for an already shaky democracy, a democracy that, permits a candidate to be elected president with the minority of the popular vote, that permits gerrymandering, that by a 5-4 decision repealed a key section of the Voting Rights Act that has allowed voter suppression. So we're already a country in democratic crisis, and we're facing the situation where there's this massive inequality that is going on. And we've talked about some of the impact in terms of the healthcare, but of course we've also seen firsthand in Newark, the long food lines and sort of the exposure of the fact that a large portion of the country lived paycheck for paycheck, and they didn't have savings that they could draw upon. So there's an enormous amount of divergence in our country in terms of the experience, because as you see these disproportionate mortality rates, and you see sort of the amplification of systemic inequality, you see that Apple, had a $2 trillion, capital cap. You see that the billionaires are getting richer. You see robust real estate markets in the suburbs. You see the stock market going up, right? So, the question is whether this country that was already experiencing a shaky democracy can continue to thrive, whether our social contract is unraveling to such extent that it really makes us on the verge of what many commentators have already called a failed state. And I understand that that has a technical meaning for people in the international law community, but we are seeing in real time the fraying of the social contract. And the question is, what happens now? And the question for us in legal academia, right, and for us lawyers and for the law students and those who practice law is, what is our role now that we see in real time an unraveling social contract? What is it that we teach our students? What type of activity do we engage in in order to address these issues. And there's really two answers to that, in my view. The first answer is a more traditional answer, but that is to start thinking of, really novel and aggressive forms of litigation. And let me give you an example. I think in the essential worker space, I've been really privileged to work as a board member for an organization that's really taken the lead in terms of representing the meat packers across the country. And they're really experimenting with common law public nuisance doctrine. They're challenging OSHA to enforce its regulations. They're bringing disparate impact cases. They have a disparate impact case pending against Tyson Foods because the disproportionate number of workers at the Tyson food plants are African American, Latino, and Asian. So there's a lot of aggressive litigation going right now. There's a lot of, I think, very creative lawyering going on right now. But I think that we need to really heed the call of Professor Lopez earlier and really sort of re-examine the role of lawyers at this moment in history. And this is where I think we go from the great pandemic to the great reckoning. I was asked to write an article for the Rutgers Law Review on the impact of the pandemic. And and I started out by using the analogy of immigration because I felt like we were all moving into a different area. But when George Floyd was murdered and marchers went into the street, I threw that away. And I started to look very closely at what was happening and some of the key features of the Black Lives Matter movements and of these protests against police brutality. And they're based on a couple of key features. One is really the notion that you can't sit on the fence as a neutral. And that's where the mask comes in as a metaphor, right? The mask comes in as a metaphor as either you are protecting your neighbor or you're a threat to your neighbor. It's that simple, that you can't be neutral on the whole issue of racism, and that you have affirmative obligations, whether you're from communities of color or not, to speak up to racism. And then the other thing that I think is really important is that these organizations have been organized in a very flat, non-hierarchical manner. Really reflective, I think, of what you saw in many respects of the Black freedom struggle in the South and Ella Baker. Like Ella Baker famously said, strong people don't need strong leaders. And so what you see with many of these organizations are the empowerment of the community, the empowerment of these communities and individuals who may be electorally disenfranchised by this court or that court and may live on the margins economically, but are giving them voice. And by giving them voice, which has not yet been taken away in our democracy, you actually function as a revitalization of democracy. You see this around the country, around the world. You see this in Hong Kong, you see this in Chile. This is sort of the organization. And I think it really is worthwhile for all of us as legal professionals to really think of what our role is in what can only be described as a pro-democracy movement in the United States. Thank you.
Thank you so much, Professor. And now to our last panelist, Leanne Fleet.
All right. Thanks, Emily. I really appreciate that. And thanks so much to Professor Iglesias and all of the panelists. It is really nice to be here with all of you today. I am struck by the complexity of all of the issues that everyone has talked about and kind of the interwovenness of all of these issues. I think Professor Epperson said it really well. Everything overlaps with each other, and that's a really complicated thing for us to take on as lawyers and as law students, but also I am struck by sort of the significance of this moment and the opportunity for us to take this on as a profession. You know, what I'm going to be talking about today is looking a little bit more deeply at the employment context and specifically looking at the impact of caregivers of the pandemic in the employment context, And I was chatting with somebody yesterday on an interviewing project that I'm doing, and one of the things that they said was, this is really an interesting moment because all of these issues that for many of us who sit in positions of privilege have felt very distant at different times in our life. This is a moment where many of these issues have been much more in our face, and they have been much more a part of our own lives, whereas at other point in times they may have been more theoretical to some of us. And I think this is a really sort of significant moment for us as a profession to recognize that we are all impacted in some way, some more than others, as we have all talked about today, and as I'll reference in the caregiving context. But we have a lot of opportunity here, and so for as complex as it also feels very, very motivating. So my piece of it, I'm just going to talk a little bit about the employment context and the caregiving piece of it, as I mentioned, the impact on our caregivers and the disproportionate impact on women, and in particular women of color, who do take on caregiving roles in the home, whether that is for children or for other individuals, vulnerable adults, and other people that may be in our lives. And as all of the other panelists have talked about, this pandemic has disrupted every aspect of our life, including our professional life and our workplaces. And since March, when the pandemic was declared, and we have all found ourselves in this situation because we are all employees, or we know employees. Employees have been navigating a new normal that in some cases includes complete losses of jobs in certain employment sectors, no access to regular care for our children or for other vulnerable family members, no access to in-person consistent schooling for our children. And Professor Epperson did a great job talking about the impacts of that. And at the crux of this, very few legal protections in place to protect us as employees when we are dealing with these things. If the pandemic has revealed a lot of things to us, and it has revealed some major gaps in our infrastructure as a society in terms of what we expect is going to happen with our children every day, and who's going to care for them, and if we are in families where both parents work, or if single parent families where one parent is working. We've made a lot of assumptions as a society how these things are going to get taken care of, and COVID has really disrupted all of those assumptions and forced us as parents and caregivers to try to strike now a balance between taking care of our children and still keeping a foot or 2 feet, if we are able, in the professional world. And this is particularly significant for families who, as we are moving into, and we are now in the start of a new school year for our children, who are now trying to sort of balance this tricky piece of having to provide some type of schooling for our children that may not be what we have become accustomed to, is certainly not what our whole societal infrastructure has been calculated on or based upon, but this is our new reality for this moment, and we have to figure out how to manage that, and also manage the professional consequences of that. And there are professional consequences. There will be professional consequences of this for many people, and particularly for women and women of color. And much like what many of the things we've talked about, the total consequences of that are not yet known. There is still a lot of unfolding to do in the next 3 months, 6 months, and years beyond that. But the impacts of this are foreseeable. We can foresee that there will be situations of employment discrimination, retaliation, and termination based on certain characteristics that people bring into the workplace, because we have women, and we have women of color in particular, who do take on this caregiving role in more family situations than not. And certainly discrimination and retaliation and termination are violations that are prohibited under the Civil Rights Act, but the current work environment is ripe for those situations to arise. And the rules that have been put in place, the laws that have been put in place, particularly, and we'll talk briefly about this, related to COVID, are insufficient for the enormity and the longevity of the pandemic as we are now experiencing it. One way that this is often referred to is caregiver discrimination or family responsibility discrimination. And that is something that existed before the pandemic, right? Discrimination against caregivers in the workplace has been on the rise for quite some time. Between 1998 and 2012, family responsibility discrimination case filings increased 590%, while the number of employment discrimination cases in federal court decreased 13% overall. Employee caregivers are not specifically a protected class under federal law, and so one of the challenges for caregivers who are impacted by this situation is they have to raise their claims under the current protections that do exist based on gender, based on race, based on a variety of different things depending upon the jurisdiction that you're in. Looking at our present situation here with COVID, the protections are limited. There are, our existing laws, the Family Medical Leave Act, for example, did not contemplate something of this longevity. There is a new federal leave law that was introduced in April of this year called the Families First Coronavirus Response Act. But also, if you look at the details of that act, and I won't spend our time together getting into the details, but suffice it to say, the law was signed in April or in March of this year to go into effect in April, and it expires at the end of December. And I am not sure any of us are anticipating that the pandemic will be over by then and that all of these situations will be resolved. And so we have a legal framework that has been put in place to help caregivers in this moment, but the legal framework that was put in place some months ago is not sufficient for what needs to be, what the realities of what we're dealing with are. There are also many uncertainties about the law that are still being defined as we go. Even as of last Friday, the Department of Labor was coming out with additional instruction, additional clarification on the FFCRCA and talking about what the implications were for requests for intermittent leave and things like that. The FFCRA also does not cover everybody. It covers people who work for employers of fewer than 500 employees, but there's no coverage for people that work at organizations over that. The FFCRA also does not cover non-parental caregivers. Do I have just a couple minutes? Is that what I heard? Okay. Go ahead.
Oh, so 2 minutes.
Okay, thanks. All right, sorry. Non-parental caregivers. And so there are huge gaps. And the important piece of this is that the significant gaps are on women, and women of color in particular. We hear about the motherhood penalty and we hear about the fatherhood bonus, and we understand sort of in the general kind of, in our general professional context, that women make less than men and women have fewer opportunities than men. But we also need to understand in this particular moment that women of color make certainly even less, but are also working in areas, in industries and in positions by large proportions that are more impacted by the pandemic and who are having to make more difficult choices related to caring for children and whether they are taking time out of work to do that. We also have to acknowledge that there is very little guidance around this, and that employers are sort of building the pipe as they go. The policies around this from the employer side are insufficient because this was not anticipated, and so they're figuring out these policies as we go, and with very little guidance. And the impact on that in this moment is significant. And the long-term impact for women and women of color is really extraordinary. So the pandemic has really pulled back the curtain on the gaps in this area, in our employment system, our healthcare system, our childcare system, and our education system. And with respect to the childcare, really given a rise to a nationwide caregiving crisis. But this is our moment to get it right. This is our moment to do it better on all of these issues that have been raised today, including caregiving. And there isn't one of us that hasn't had some personal experience with this. And it's not somebody else's issue now. It is our issue, and it is our opportunity and moment to fix it as lawyers and as law students and as future lawyers. And I'm looking forward to continuing the discussion together. So thank you.
Thank you all. This was a great panel. We have about 15 or 12 minutes for question and answer. And we have some questions here for our panelists, starting with using housing to anchor this question, and as it relates to not only the primary means of personal and community stabilization, but also wealth transfer for much of America. What analysis, if any, has been done to understand statistically how harmful the intergenerational effects may be to Black families who have experienced this historically? And this is for all of the panelists.
Well, I mean, I mentioned just briefly in the discussion of education, the role of housing and housing segregation and the impact that it has on the concentration of poverty and the intergenerational transfer of wealth. So there has been actually quite a bit written about that connection to racial disparities, the role of intergenerational wealth transfer and the role that housing plays in that. One of the things that most recently has come out that I think received a lot of attention was Richard Rothstein's book, The Color of Law, where he kind of outlines the history of American policy on this, around the FHA and around the private mechanisms like redlining that contributed to this racial disparity in access to housing and in wealth transfer. That's one example.
Okay. And so if there aren't any other panelists that will answer, I will move on to the next question. Have children with disabilities who have individualized education programs received their services virtually due to remote learning? And if so, does it appear that their educational growth will be hindered by such remote services?
I can only answer from New Jersey and Arizona, where my sister's a public school teacher. The answer is no. This has been a complete disaster, as it has been for poor children generally. But I think that students with disabilities are really falling behind. And I think that there really was not adequate guidance from the Department of Education or often at the state level about how to provide education, during this unforeseen pandemic. So it's a tremendous challenge. And I think like so many students we have right now, they are falling behind. And I know that we have a clinic that's dedicated to these issues here at Rutgers. And they've been working 24/7, just trying to fight for students, one student at a time, to make sure that they are able to secure their IEPs with the local school districts.
There have been a couple of lawsuits as well, I think in Pennsylvania and in Hawaii, because of exactly what you're mentioning, this notion that they're not providing, we're really left without adequate education at every stage, but you could really see it with respect to the provision of special education in public schools. And so being able to comply with FAPE under the IDEA is a real issue. So I think in Pennsylvania and in Hawaii, there have been lawsuits against their education departments to say they have not actually provided adequate education pursuant to IDEA for students with special needs in this time of COVID.
But I would also say that it's not one size fits all. So there are some students with disabilities for whom being online has been a tremendous boon. Right? And so I'm actually the parent of one of those children for whom there's less bullying, there's more time. Teachers are having to be more creative in terms of assessment. There's a different kind of lessening of pressure. So I think that it's a more nuanced and complicated answer than it's just been bad for some students. Some students have really welcomed the different pace, the reduction in sensory overload that often happens when you're at school in a learning environment with lots of different people. The ability sometimes to get up later in the morning, and so you don't have that rush, which for some people with disabilities is like, just come on, we've got to go, we've got to go, we've got to go, and then that triggers a meltdown, right? So I think it's nuanced.
I'd like to just add to the scope of the problem is that there are 7 million children in this country of school age with disabilities. And these children are always the ones who are the most vulnerable to rollbacks of programs in place, the suspension of special education services. And then with Education Secretary DeVos, I understand throwing around talk about waivers of liability in connection with whether or not they need to comply. So there's a lot of confusion in distance learning, particularly at the beginning of the pandemic. I also would like to situate the discussion a little bit in the Southeast to the extent, although Dean Lopez up in New Jersey, you may have to worry about this also. There's now currently something like 7 hurricanes spinning around the Atlantic, so that we've got forecasted 5 major, that means 3 or category 3 or plus major hurricanes that are yet to come before the end of the season, which then further complicates the delivery of special education services, which has already been compromised by the pandemic.
I would just also add to this, and it's a point that Professor Scott made that I think is really a good one. And I too have a 4th grader right now who I am home teaching, and he has special needs, and he is having the opposite experience of, you know, the distance piece of it is very challenging for him, and it's hard to imagine a circumstance under which that is not the case for probably many, if not most, of the students that we are dealing with, and for the parents who are, you know, helping them because of that pipe, you know, because we are sort of building this as we go. It is impossible to imagine why that would not be the case. But Professor Scott's point, I think, is really good, that this is a moment for us to think about who does this work for and who does this not work for, instead of sort of thinking of our job as how do we get ourselves back to where we were? How do we learn from this and learn what is better for a certain segment of the student population? What pieces of this are good that we want to keep, and what pieces of this are not working? And I think there's a pretty good list on both sides.
Thank you, all of you. Actually, back to Leanne, a question now is, what are feasible steps that employers can take to protect caregivers who are disproportionately women and women of color in the workplace?
Yeah, I mean, I think it's a really good question. It's a complicated question, and I think it is something that we have to look at in the short term, and it's something that we have to look at in the long term. The short term immediate needs, and this is challenging from the employer perspective as well, because they are balancing sort of, you know, their businesses, their nonprofits, whatever organization they're part of, but to offer, you know, flexibility, to ask people what they need, to be as flexible as possible, and really to understand what the potential is for disproportionate impact on women and women of color. And, you know, that's not something that we have spent enough time talking about up to this point. And, you know, for all of the conversations that we've had about it, you know, from the employer perspective, I think this is a really tricky area to navigate. There will be litigation arising out of this. There already are. There, you know, are 24 cases that have been filed since April just on this caregiving issue. And with that is, you know, we have not even sort of brushed the tip of the iceberg there. And so whether it's intentional or unintentional, there will be missteps on the part of employers. But I think the best thing that they can do in the short term is to offer as much flexibility as possible, to ask good questions, to be really sensitive to what the disparate impacts are. And in the long term, I think that's a larger question that we have to answer as a society with, you know, our employers as part of it. How do we create a better infrastructure so that things don't come to a grinding halt when, you know, people need to stay home with their kids, and they don't feel the pressure to make really difficult choices like that?
Thank you. As a last question, we have about 2 minutes. Anyone is free to answer. What are some feasible steps that law students, attorneys, and other adults may be able to take to prevent the widening of the education gap?
Well, I just to comment again on Dean Lopez's entreaty that people engage in novel, aggressive, good litigation. And there's this fantastic case out of Compton, California, where the students and teachers in Compton, you may be familiar, are suing the school district, alleging trauma as a class on behalf of Black and Latino students who are living in poor, violence-torn inner-city communities, and they're seeking federal disability law protection and consideration in the form of teacher training and counseling and change disciplinary practices. That's the kind of litigation I like to see.
That's a great example. I agree. I echo that. And I think that what all of us are talking about are the fact that we've talked about all of these connections between these various layers of inequality, and there are both short-term and long-term goals that we can have. The short-term are like, what do you do right this minute to change what's happening in this particular school district, or to argue that IDA is not providing what it needs to? But the long-term is really a redesign of how we look at education and opportunity in the United States. And it's using all of the pieces that we've talked about, things like data that we understand now about things like racial trauma and racial anxiety and implicit bias and stereotype threat, and how that impacts things like access to education and how it differs for various communities in terms of things like Dean Scott talking about the notion that at home can be better for some, but it also can be better for privileged some who have a parent available to be able to guide them in that. And so these all suggest there can be new frameworks that new lawyers are working to implement, armed with an arsenal of information and tools that really weren't at our disposal, say 20 or 30 years ago, litigating education cases.
And I would never underestimate the importance of bearing witness and actually working with the students directly to fill in some of the gaps. I know that our street law program has partnered with one of the inner city high schools and work with them directly. And, you know, this really gets at both some of the special education issues, the digital divide issues, and the caregiver issues, because many of them have parents who cannot be with them during the day because they must go work on, you know, the MTA transit system or PATH or wherever they work. And so they're not there. I mean, and that's, you know, and I deal with caregiver issues as the dean with our faculty. They're not issues, they're challenges. I love my faculty, they're challenges, and they're facing challenges as are our students. But they're home working on the computer. Many of the parents aren't home, and the kids still, you know, need to be educated if we're going to have any small glimmer of hope that, you know, this is a meritocracy and we might achieve a meritocracy at some time in our children's lifetime.
Thank you. Thank you all for your time and your participation. This concludes our panel. I will now move it on to the next moderator for our final panel.
Thank you.
Good afternoon, everyone. My name is Leandra Lopez, and I'm the president of the Miami Law Cuban American Bar Association chapter. I'll be moderating this panel today. Our distinguished panel will focus on the civil rights issues the pandemic has exacerbated in and around the rights of citizenship, exclusion of immigrants, and treatment of Native communities, including but not limited to citizenship-based discrimination in access to federal relief and health benefits, mass deportations, discriminatory treatment of naturalized citizens, violation of voting rights, and public health rationing. The order of the presentation is as follows. Opening the panel, we have Professor Raquel E. Aldana, Professor of Law and Associate Vice Chancellor for Academic Diversity at the University of California, Davis. Next, Professor Kathy Culiton Gonzalez, Chair of the Civil Rights Section and co-chair of the 2020 initiative of the Hispanic National Bar Association. Following, we have Professor Heriberto Roman, Professor of Law and Director of Citizen and Immigration Initiatives at FIU College of Law. And then we will conclude with Professor Susan Serrano, Associate Director and Director of Research and Scholarship at the Kahuli'au Center for Excellence in Native Hawaiian Law and Professor at University of Hawaii at Manoa and William S. Richardson School of Law. We thank you all for being here today, and we look forward to learning your perspectives on these timely issues. As a moderator, I will be keeping time for our esteemed panelists, who each have 10 minutes to speak. When each panelist has 2 minutes left, I will turn on my microphone and indicate to the speaker and say 2. At the 10-minute mark, I will again turn on my microphone and say time's up. It's very important that the speakers be ready to hand over the podium, virtually of course, to the next speaker when they hear that time is up. If each speaker does this, everyone will have their say, and it'll be a 15-minute question and answer period to conclude. Please let us know if you have any questions by participating in the Q&A chat. I'm now going to hand it over to Professor Aldana to get us started. Thank you.
Thank you so much. I want to begin by thanking Dean Varona and Professor Iglesias, my co-panelists and the audience, because if you've been with us since the beginning, you're a hero, my hero. If you are just joining us, we're very appreciative of your presence. I do want to say thank you to the staff and especially to the IT team. I do have a presentation, PowerPoint, and so I think I'm going to go ahead and try to share it from my screen. So I've titled my talk, The Pandemic's Long-Term Economic Reckoning, a look at remittances and forced migration for the Northern Triangle. This past December, while visiting the highlands in Guatemala, I co-authored a white paper titled Connecting Past and Present, Central America's Forced Migration as an Unfinished Project of Building Just Nations, Post-Colonization, Post-Conflict. This paper was commissioned by the Border Humanitarian Health Initiative led by 4 of the University of California campuses, Stanford University and several Mexican universities. The Border Humanitarian Health Initiative was bringing together a coalition of multidisciplinary leaders in academia to respond to the humanitarian human rights crisis at the US-Mexico border. And the goals was to respond urgently to this health crisis by reducing the health burdens, but also by protecting human rights and starting to address the root causes of forced migration in the long term. So I was both inspired by the resilient beauty of what the Guatemalan highlands and its people, but also quite angry at what I saw happening in the United States in its treatment of Central Americans, especially at the US-Mexico border. So I was hoping with my co-authors to both be bold and courageous in crafting a vision for moving forward, but at the same time wanted to express our humility and our profound awareness that this project of really embracing the root causes of forced migration has been a violent project that has taken over a century. So this quote is simply the way that we framed our paper. So in the white paper, we attempted to modernize a vision for building just nations in the Northern Triangle. And we did 3 things. We provided prescriptions that de-emphasized, at least in the short term, the role of nation states in favor of more decentralized solutions that included local governments, indigenous communities, and others. We also talked about important cross-border solutions that account for the ever-present transnational agency of the problems in the region. And we took up issues both new and old through evolving frameworks connected to human rights and sustainable development. In the end, the paper provided over 50 recommendations. Clearly, I won't have the time to talk about those today. Don't worry, I don't intend to. The idea was to provide holistic solutions for interrelated problems that are provoking forced migration in the region, to name a few: insecurity and corruption, climate change, exploitation of resources and workers, and profound persistent inequality. Our solutions touched on really bold ideas over a range of issues like the liberalization of drugs, trade reform, desperately needed local reforms, such as the regulation of taxes, water, and education. So today I only touch on one of those proposed solutions, the role of remittances in promoting sustainable economic development in the region. And what I've provided there, and I won't read it for you, was our definition of what sustainable development should mean in the region. And we also recognize that remittances is only one of multiple solutions that we included in the section, many of which had interrelated transnational dimensions. And here we also want to highlight the necessity of the remittances issue to collaborate with localized projects in the region. So capitalizing on remittances to promote this collaboration and local approaches makes sense in Latin America. Many of you have heard the data. This is just a chart that reiterates the importance of remittances as an economic force in the region. Only Haiti's remittances, which were 39% of the gross national product, surpassed in 2018, surpassed El Salvador's and Honduras' receipt of remittances at 21% and 20% respectively. And Guatemala occupies 5th place in terms of remittances as part of its gross national product in the region at 12%. So remittances have provided significant poverty alleviation to the region. They also have inadvertently introduced social and environmental stressors through uncoordinated development and increased consumption and inequality within communities. Moreover, with few exceptions, the sending of remittances to the Northern Triangle region remains both too costly and largely individualized for family contributions rather than coordinated efforts to promote collective sustainable development in the region. But I do want to highlight that there are models elsewhere in Latin America, especially in Mexico, that are starting to emerge also in the Northern Triangle, where remittances have been employed effectively in partnership with local governments, local communities, and organized cooperatives to really reimagine what it would mean to capitalize on this economic strength to help people be able to live dignified lives and not have to resort to forced migration. Of course, the promise of remittances in the Northern Triangle region cannot be disconnected from US immigration policies, both pre-COVID-19 and of course during COVID-19. And even pre-COVID-19, Manuel Orozco and his colleagues in this study that they conducted in 2018 about remittances from the US to the region predicted that immigration from the Northern Triangle countries, while it has continued with an estimated 150,000 migrants from El Salvador, Guatemala, and Honduras, it will start to go down. And I think that this is a reflection both of the incredible machinery of enforcement that has been waged against this community, both by the United States and Mexico. So, though the migration continues, right, it is important to understand that it is ongoing at a much slower rate, no matter what they tell you about the humanitarian crisis at the border. And this decline is particularly noticeable because the patterns of deportations has remained steady for this community. And in fact, the highest number of deportations also happens to coincide with Central Americans. And eventually, because most Central American migration in the US is irregular, these deportations are going to increase. And many of you have probably been following that the Ninth Circuit just last week did not uphold a nationwide injunction that had tried to stall the ending of temporary protective status for Central Americans. This will impact over 300,000 Central Americans who now will face the possibility of deportation. So what do we know is happening today with Central American migration in a COVID-19 reality? So 2 minutes? Okay, so I was unable to find good data tracking what net migration of Central Americans is looking like since 2018, the data that I provided. But what we do know is that while thousands of irregular migrants are desperately trying to get to the US, hardly any, I would even say maybe zero, are getting past the US-Mexico border due to various Trump policies that predated COVID-19 and of course were reinforced during the COVID-19 crisis. The New York Times also reported that there have been clandestine deportations occurring all along. They actually did a study that was tracking these flights, and it's not only happening, but it is spreading COVID-19 all over the region. And what we also know is that the New York Times recently also reported that these immigration raids now will be ongoing as an official policy of the Trump administration. And of course, we cannot ignore the ways in which the Trump administration has been successfully utilizing the administrative apparatus, both pre-COVID-19 and post-COVID-19, to achieve his aims of significantly reducing family-based immigration. And this slide simply gives you some data of the significant ways in which the numbers have completely shifted pre-Trump administration, where about 1 million immigrants lawfully came to the United States, to the numbers that you see today. So what are the implications of this on the topic of remittances? Well, one of the things, and this is actually coming from a report by the Congressional Research Service, one of the things to think about is that to the extent that remittances were filling these voids and trying to deal and alleviate the extreme inequality and poverty in the region, to the extent that the forecast is that migration will be reduced, what we know about essential workers in the United States and the impact of the virus, what the predictions initially had been with the IMF and World Bank is that these remittances were going to significantly go down for Latin America. It turns out that in the last months, in June and July, the remittances have gone up. And so I will finish here. They have gone up, but I don't think this is sustainable, right? They've gone up because I think of the incredible generosity of our people who sacrifice themselves in light of what is happening in our countries. People are literally starving. But what we know is that the economic reality will worsen in Latin America. These are some predictions of how the pandemic will impact poverty in the region. And our migration policies and what we're doing cannot be disconnected with the ability of these nations to reimagine their future. So thank you.
Thank you for your presentation. Next, we have Professor Kathy Cuyiton Gonzalez.
Hi, good afternoon, good evening. I first should say I'm not a professor. I'm a former professor. During a Fulbright year in Chile, I got to teach human rights law in 1993. And since then, I've been practicing human and civil rights law. And I'm here in my role today with the Hispanic National Bar Association. And I want to say thank you so much to Professor Iglesias for her leadership and for joining us as the Hispanic National Bar Association as our constitutional law section chair and inviting me to be part of this prestigious panel. I also want to say thank you to Dean Varona, and it's a tough act to follow Professor Aldana, but I'm going to try to do so. I want to thank the law students who I hope will become future human and civil rights lawyers, because we will really need you in the reckoning and reconstruction that current conditions portend. To quote Professor Torres' opening remarks, the COVID pandemic the conditions of the COVID pandemic and these emergencies have revealed themselves rather than being created by the pandemic, and they challenge fundamental governing norms for internationally and for our country. And I'm going to talk about navigating American concepts of race and citizenship and immigration and democracy in 2020. In short, I'm going to talk about voting rights. Naturalized citizens, and may I say that voting rights are connected to the policies that we would like to see change and to the problems that folks have been talking about all day. Naturalized citizens, the immigrants that we've just been discussing, who become naturalized citizens, have finally become a significant part of the American electorate. In 2020, naturalized citizens totaled 23.2 million, or 1 in 10 eligible voters. Naturalized citizens vote at higher rates than persons born in the United States, yet they face many obstacles to exercising their right to vote. And as the nation is poised to potentially update and restore the full protections of the Voting Rights Act through the John Lewis Voting Rights Act, respectfully, to honor his legacy, the needs of naturalized citizens should be considered. And I also posit that Congress has appropriate authority to do so under the Reconstruction Amendments, the 14th and 15th Amendments. In 2020, barriers to the right to vote for communities of color include not only barriers to the ballot, but also precedent barriers to access to citizenship in the first place. And both categories of barriers are incompatible with the promises of the 14th and 15th Amendment. I also posit that barriers to becoming naturalized are part of what's considered the totality of circumstances that can be taken into account in evaluating violations of the anti-discrimination provisions of the Voting Rights Act. I would like your help in counting the barriers in the path of naturalized citizens to be able to vote in the 2020 elections. First of all, current data shows that the great majority of naturalized citizens are voters of color. 34% are Latino, 31% are Asian, and 10% are Black Americans. So they suffer the same barriers that members of these races suffer in the path to voting. But also in the path to citizenship, we need to update the significant barriers that have been erected in the changing demographics of immigration in our country. And these barriers parallel the historic barriers to African American, Native American, and Puerto Rican citizenship, along with barriers to birthright citizenship for people of color. These barriers have increased during the Trump administration, and this has been along racial lines. First, there's Trump's denaturalization force, for which they've recruited new staff to specifically denaturalize citizens based on alleged criminality, another extension of what's properly called crimmigration. Second, there's the high cost of naturalization. It was $640, already prohibitive, and on August 3rd, it was increased to $1,160, and that's for the naturalization form only. Data trends suggest that this increase, of course, and making the fee waiver more complex to access, is expected to reduce naturalization applications by 10%. And then since the onset of the COVID pandemic, the backlog in naturalization applications, which is already problematic, has increased, and it's leaving out tens of thousands who expected to naturalize in time to vote in 2020. These barriers to naturalization directly impact the potential 2020 electorate and the future electorate, and the ability to elect candidates of choice. And I'm using the language of the Voting Rights Act. Further, there's a chilling effect due to increasing immigration enforcement at all stages of the path to citizenship. As Sova Sivaprasad Wadhia has documented, immigration services, that means applying to benefits such as a green card and naturalization, have been mixed with enforcement due to a 2018 memo instructing USCIS to issue notices to appear, that is, notices for enforcement actions against persons whose applications for benefits they are reviewing. And Shova summarizes that people today can go into a naturalization interview and come out in handcuffs, subject to deportation. That's another barrier. Shova says that would have never taken place at INS. And in the past, if people were eligible for benefits, the view was they should be given the opportunity to have their cases reviewed. But I would argue that this view actually began in the 1996 immigration reforms under Bill Clinton, and that is a fifth barrier. It started crimmigration, and it took away the path to legalization for persons who had been out of status but otherwise entitled to legalize. In my estimation, over 80% of currently undocumented immigrants, again, the majority from Latin America and the supermajority people of color, would have had access to legalization if it were not for the 1996 reforms. Now, being a civil rights lawyer, I can tell you that these days the disparities are insufficient proof. However, we have more proof that these are racial inequities and that this is problematic discrimination. The past barriers came about in the context of the crime bill and the welfare reforms of the same era, and they came about the decreasing access to legalization, and citizenship came about as the demographics of immigration were changing, becoming less and less majority white and more people of color. This era that we're living in now has brought to light the racial discrimination inherent in blocking access to citizenship for entire generations of immigrants in ways that have not been done in the past. And to use civil rights language for immigration problems with voting, these policies are pretextual. They're not needed to meet the stated government interests, and federal courts have held so over and over in these cases. The basis of the 1996 forms were national security and safety, and the basis of the Trump era reforms are similar, but the facts belie these assertions. Instead, the path to citizenship has been repeatedly narrowed and outright blocked as the demographics of immigration have changed and become majority people of color. Now, there's another aspect of discrimination, which is outright racial discrimination, intentional discrimination. And in the past, the record wasn't as clear in immigration cases. A lot of the cases in the past either had discrimination claims settled, that, for example, in the ABC, American Baptist Churches settlement, that became temporary protective status in the fight against Prop 187, and even in the fight against HB 1040 of Arizona, Arizona's anti-immigrant law in 2012. We don't see surviving racial discrimination claims, but we do in the current era. And let me just keep naming those as blocks in the path to citizenship. We have 3 Muslim bans. We have the unconstitutional use of local police as federal immigration agents, the increase in criminalization of immigrants, the cruel and discriminatory family separation policy, mostly impacting Central American families, the outright rescission of DACA, and the outright rescission or taking away of legal status of temporary protective status for Central American and African nationals. We have heard the president's remark of what he thinks about these nationals. I know I have just 2 minutes. I want to say that now we have a better record of the racially discriminatory blocks in the path to citizenship, to naturalization and becoming citizens in the first place. In the voting process, we are also seeing increasing racial barriers to voting during the time of coronavirus. This is nothing new, but as everyone's been saying, coronavirus has exacerbated the problems. Newly naturalized citizens, again, majority Black and Latino, need more assistance in order to be able to vote, but yet they receive less assistance at the polls. Further, Black and Latino communities and Asian communities as well have been experiencing higher rates of coronavirus. They have greater risk if they go to the polls to vote. They're essential workers, and systemic disparities have led to these higher rates of coronavirus and the higher risk at the polls. And this type of long-standing systemic health and social inequities is the same type of language that can be used in voting rights claims. And I'm quoting the CDC, the federal CDC, talking about long-standing systemic and social inequities that have put people of color more at risk of coronavirus. In addition, naturalized citizens have additional language barriers. They're much more likely to be challenged, unfairly put on the purge list. The voter ID laws also have a disparate impact on naturalized citizens, more than other folks. A copy of one's naturalization papers is now $535. And I would be remiss if I didn't discuss in Florida a case I was involved in, Arcia versus Stetzner, in which Black and Latino naturalized citizens were put on a purge list merely because they were not citizens born in the United States. This is a form of racial discrimination that should be taken into account as we go about looking to resolve the problems with the Voting Rights Act. And further, it should be taken into account as we go about resolving immigration reform and as we ask the next administration to ensure that there is a path to citizenship, because to ignore these types of racial discrimination would contravene the promises of the 14th and 15th Amendments.
Thank
And
you.
I want to say just one final note really quickly. At HMBA, we know how important this is for Latinos. A quarter of Latino eligible voters are naturalized citizens. And that's why we don't see these two issues as separate. We have calls to action in both regards, and we would like your help in making sure that the next election includes protection of voting rights for naturalized citizens and that we make these systemic changes going forward. Thank you very much. I'm looking forward to questions.
Thank you for your presentation. We now have Professor Ediberto Roman.
Make sure I unmute myself first and foremost. I want to thank Professor Iglesias and Dean Varona for given me the opportunity to present here. And I also want to warn the moderator as well as my panelists, this is my second panel in 2 hours. So if for some reason you start hearing me talk about impeachment and the Constitution, just say and I realize I'm at a different panel. That's tongue in cheek. I certainly hope I won't get there. Looking at the subject matter and the heading, right, in terms of the effects of the pandemic on immigrant community, I really thought about labeling my talk, right? Because when you look at this issue, right, particularly for undocumented immigrants, you're talking about among the most vulnerable group in our society, a group that is terribly important economically in terms of taxes, in terms of doing work in sectors such as agriculture, such as service industries, such as construction, and a group that in no uncertain terms has been either dismissed or outright attacked by President Trump. Just think about how he started his campaign. But looking at it specifically in the context of healthcare, we have to examine the fact that, you know, this is a vulnerable group, particularly the undocumented, that essentially lack readily available and affordable healthcare. During the pandemic, the consequences of that we all can appreciate in terms of how dire they are. So in terms of this group, this vulnerable group, they are often or typically underinsured or uninsured. As a result of that, they have to depend on federally qualified healthcare centers, safety net public healthcare system, free clinics, or clinics which they have to pay themselves, putting pressure not only on them economically, but also on the rest of the society. And in the short-sighted vision that we have under this current administration, the pandemic just exacerbates the problems that are cutting off our nose to spite our face mentality. Then you look at another consequence that's endemic to this community because of economic circumstances more than anything else, and not that different from those sectors of our society that socioeconomically are in a struggling situation. And that includes a lack of access to preventative medicine, right? Underlying health conditions such as obesity, hypertension, diabetes, oftentimes, right, consistent or related to the lifestyle choices and the lack of choices because of their economic circumstances. And the last prong I want to focus on is something that I've spent, frankly, decades writing about, is the impact economically and psychologically with respect to xenophobic policies and practices. Can think of no more no president that has pushed this sentiment of hate and fear among immigrant communities. And we shouldn't lose sight of the fact that when we're talking about these issues, these are not issues that are limited to immigrant communities, and particularly undocumented communities. That this has a slippage effect with respect to documented immigrants and the Latina community, or those perceived to be outsiders. So this is not an isolated issue in terms of a utilitarian perspective as a way to breed empathy and convince others to appreciate the impact of these issues. But when you think about the promises to deport millions of immigrants, it was part of his initial campaign. You hear less of it now because it's not at the heart of it. He has a pandemic to struggle with. But also the roundups, the high profile roundups, and you do see from time to time commercials with respect to Biden wanting to provide health care for undocumented immigrants, and just false statements to that effect. The consequence of that behavior is basically just to promote fear, to essentially ensure that access to basic resources either are not available because of hostility within given states, or the individuals themselves, right? The external impact would be the states and the federal government making access difficult, and the internal impact of the anxiety and fear that is the result or consequence of these hostile tactics. And study after study that have examined these issues have pointed out that the consequences are real in terms of the overall impact on these communities. Think about other socioeconomic impact of the pandemic on U.S. immigrants is the fact that much of the relief, be it the CARES Act, right, and other efforts to assist, right, society is not available to undocumented or families that are mixed families of immigrant status. So further coupling, right, the negative impact, not only from a healthcare standpoint, but from a socioeconomic standpoint, that to the extent there is a relief available, it's not made available to key, right, members of our society that hold jobs that are integral to our success as a society, but yet are not only in the shadows, but are hit with a double whammy, right, of being demonized on a regular basis to the extent that they don't seek access to the care that they have that is available, and even that care is nowhere near the amount of care that is available to other groups. And look at how recently some studies and reports have examined this issue and the double whammy I'm alluding to. The Washington Post this summer examined the issue and said basically the collapse of the US economy brought about by the coronavirus pandemic has exposed the extreme vulnerabilities of millions of undocumented workers who are disproportionately employed in industries or undergoing mass layoffs, as well as high-risk jobs that keep society running while many Americans themselves self-isolate. This is a set of errors that is unfathomable in a society that you would think in the 21st century would be more understanding and welcoming, but it's the opposite is true. The news accounts today just highlight this point of the president's executive order to create the Trump youth, so to speak, to highlight patriotism and code, frankly, for promoting the fear and hatred of the outsider. So the consequences of the pandemic in this environment to immigrant communities, documented and undocumented, and Latino and Latina communities altogether is to promote fear, anxiety, and economic despair. The fact of the matter, this is something I've been writing about for well over a decade. The external impact is to promote not only violence in the literal sense, but also the psychological sense, a lack of care about what many view as contagions themselves. And there's obviously the irony there associated with the pandemic and the pun there with respect to the pandemic. So a group that's considered an outsider and a threat is hit harder than any other group. And the consequences are horrific. The solutions are not easy, other than the political realities in terms of what hopefully will happen November 3rd. And I just want to remind you to close here on what Wendy Cervantes and Christina Walker mentioned this summer in terms of the impacts on immigrant communities with respect to harsh measures. And that includes the literal tearing of families apart, or the perceptions of those families being torn apart, be it in the context of a literal deportation or the necessary redress that needs to be had in some fashion, be it in the US or elsewhere. The harm long-term and short-term to children in terms of their mental health, in terms of their physical health, in terms of the prospects for their future. These are all real and documented. And the final point they raise is that this is not limited to just undocumented immigrants. They're documented immigrants, asylum seekers, Latinos and Latinas, and other communities all face the brunt of these attacks where the president has overtly and systematically used policies to make us outsiders. Thanks so much, and it's been a pleasure.
Thank you, Professor. And now we'll have Professor Serrano.
Good afternoon. Actually, it's morning for me. I'm in Hawaii, but let me share my screen. Okay. Thank you so much to Professor Iglesias and all the others who put on this amazing conference. I'm really honored to be part of it. So during this pandemic and the sweeping calls for racial justice, I decided to reread James Baldwin's The Fire Next Time. And in it, he lamented how the system of white supremacy would devour young Black lives, and wondered what will happen to all that beauty. And so I thought more about the community that I live in. So I wanted to briefly talk to you today about a group of beautiful people here in Hawaii who are largely missing from the national narrative on COVID and race, who are not prioritized here locally, but who are targets of racism and who are now experiencing the highest rate of COVID in the state. And that is the community of residents from the so-called freely associated states, which are the Federated States of Micronesia, the Republic of the Marshall Islands, and Palau, kind of all part of the Micronesia region. So a couple of caveats, I guess, before. So this is not meant to supplant or diminish Black Lives Matter issues, only to draw upon that experience and analysis. Also, I'm not Native Hawaiian or Pacific Islander, but I work on race and indigenous issues. And like all of you, I care so deeply about the disproportionate impacts of COVID in racial communities. So in order to kind of understand the connection and the reality of COVID and race for Pacific Islanders in Hawaii, I want to take you folks back in time a little bit. So racialized images like these were deployed by decision makers over a century ago to justify the takeover of what are now the US territories and also the state of Hawaii. On the left, we see the peoples of the Pacific and the Caribbean portrayed as pickaninnies. On the right is Queen Liliuokalani, the Hawaii's last queen, portrayed here as a Black woman with exaggerated features. And again, here with a fiendish look with stereotypical Native American or Black features. So these images show how race, and in particular Blackness, was deployed to characterize these island peoples as inferior and unfit, less human, uncivilized, to make aggression against them appear necessary. So a lot of the same othering was used in the United States imperial takeover of the Micronesia region. Really briefly, in 1947, this region became a UN trust territory, part of a system, right, to help former colonies move toward independence. And so the goal was to foster self-sufficiency, and the United States became the sole trustee of this region with sweeping powers, including complete military control. But the US failed spectacularly in its duty. For 12 years, between 1946 and 1958, the United States, as their trustee, dropped 67 atomic and hydrogen bombs on the Marshall Islands to find out what the impacts of the atomic bomb would be. The megatonnage was the equivalent of dropping 1.6 Hiroshima bombs every single day for the entire 12-year period. Some islands were completely vaporized. Of course, horrific health effects resulted: thyroid cancers, other cancers, severe birth defects. And of course, the lands and resources were destroyed. People were forcibly removed from their homelands so they could no longer self-subsist, and then became reliant on Western processed foods, which also caused other kinds of illnesses, right? Diabetes, heart disease, other cancers. And today, the Federated States of Micronesia and the Marshall Islands have the highest rate of diabetes in the world. So in recognition of those injustices, the United States entered into these compacts of free association with these three nations in the 1980s. The US got complete military control over the region. The people got a nearly unrestricted right to travel to the United States for education, employment, and desperately needed healthcare. So again, this was supposed to foster self-sufficiency, but going on 35 years later, the US has failed to discharge its duty, and it still operates the Ronald Reagan Ballistic Missile Defense Test Site in the Marshall Islands. So as a result of all these decades of failed oversight, thousands of people from this region have established residence in the United States, primarily Guam, also Honolulu, but also there's a population in Arkansas who, and a lot of Marshallese, and a lot of them work at poultry plants there. But once they got here, right, they've been fighting for healthcare for years. They're not eligible for Medicaid or other federal benefits like SNAP. In Hawaii, they are denied state-funded public health insurance. And so for years, people have been arguing that without access to these life-saving treatments like dialysis, chemotherapy, many would die. And sadly, this turned out to be true. A new study just came out showing that between 2015 and 2018, after they were removed from a state version of Medicaid, the mortality rate of this community was 43% higher compared with white residents in Hawaii. So this is all kind of the backdrop of today's COVID reality. This chart is from about 2 weeks ago. So this community, Pacific Islanders here, make up 32% of the COVID cases, but only 4% of the population. And a lot of what's going on mirrors what's happening in racial communities nationwide that a lot of you have already talked about today. You know, they have poorer health, really high poverty rates. They struggle to access unemployment because of language barriers. Sometimes the forms don't reflect their unique legal status, so they get left out that way as well. They live in multi-generational households. They're being evicted. They're becoming houseless. They're also so-called essential workers. And they're largely missing from the state's conversations on the economic impacts of COVID. And also in Honolulu, Micronesians, Samoans, and Blacks are being arrested for violating the COVID orders at a much higher rate than their population. Here, in the green this is from June. In the green is the Micronesian community, and on the right side, you can barely see a sliver of how much of their representation in the population. So, of course, racism and white supremacy is deeply embedded in all of this. This community is targeted because of their distinctive skirts that the women wear, different ones from different nations. You know, hate against them has become normalized. Thank you. Hate has become normalized online. People are using some of the same characterizations that we heard a century before, right? They're lazy, immoral, undeserving, incapable, dirty, foreign. They're being called cockroaches, nuclear monkeys, parasites, and freeloaders. And so 5 years ago, in analyzing our nation's shared racism, critical race scholar Chuck Lawrence wrote, "In this moment in Hawaii's history, we have designated our brothers and sisters from the Micronesian islands to assume the role of Blackness." And this is still the case, right? So today, not only is this group disproportionately impacted by COVID, but the operation of white supremacy has allowed for the general disregard of those impacts. But the community itself, advocates, allies have been fighting really hard. I just want to highlight my colleague, Dina Sheck, who runs the Medical Legal Partnership here, and she works on multiple levels to address not only the immediate needs, housing, employment, healthcare during COVID, but also pursuing a racial justice vision that includes, embraces community power and challenging structural inequality. And of course, the youth. So nationally, the youth are coming together to tell each other's stories, to share, and to fight policies that affect both communities. So I just want to leave you with a photo from the start. I think of it as a photo of hope and of beauty. I took it during one of the big marches after George Floyd's murder. And this is a photo of Micronesian youth who were passing out free water and food to the marchers. And they all had the same shirt on that said, it's hard to read, so I typed it out. So it says micro for Micronesian, micro, but my heart big, hashtag Black Lives Matter. Thank you.
Thank you for your presentation. We're now going to move on to the question and answer period. And we have a few questions that have been sent to us. I'll start with the first one, and anyone can answer the questions if it speaks to them. Many politicians have promised that vaccines are coming and that they will be provided free of charge. Considering the announcement by the largest vaccine manufacturer that vaccines will not be available to everyone until 2024, how will lawmakers reevaluate their goals and expectations to ensure that the scarcity in vaccines does not negatively impact poor communities and migrant communities?
How should they or how will they?
I guess both.
Will they? No. A simple answer. I think several of the panelists spoke to that point when you talk about communities that are in the shadows. it's obvious that this is the case when there's not a pull and push to provide access to those who are perceived to be legitimate in terms of status. So I highly doubt that it's certainly under this administration, if it continues, and that, notwithstanding our fears, it's certainly a possibility, but I can't imagine it, both overtly and in terms of the psychological effects and impact on the internalization of those fear efforts. And if I may, somewhat unrelated, if someone is interested in some of the background materials Professor Serrano mentioned, I actually wrote a book on the subject quite a few years ago, The Other American Colonies, where I draw attention and parallels between the post-Spanish American War acquisitions and the post-World War II that she's focusing on in terms of the Micronesian areas.
If I can just add just a few thoughts. I'm in California, and I think that California, because I'm working so hard at Hope these days, and I'm teaching immigration law, and it's really dark to keep hope. But one of the things that I do is I bring up the innovations that are occurring at the local levels. And I taught at the very beginning of immigration law a case study on migration in the time of pandemic. And we ended with some of the innovations that are occurring state by state. And I know Florida is not the same as California, but I do want to suggest that some of the innovations have included ways in which state policies have tried to come in to redress a lot of the evil, frankly, that is coming down from the federal government today. So examples like unemployment benefits to undocumented communities, it's not enough, but it is something, and the access to healthcare in order to address it rationally as a healthcare issue. I do think there could be rational policies that think about prioritizing who gets the vaccine based on who's an essential worker, right? What is the role that they play? And what we know is that essential workers are in great numbers immigrants, and also who are undocumented, not all, but many. So there are ways in which I think local officials could reimagine, short of a re-election of someone who is rational about this pandemic, could reimagine rational ways of distributing vaccines and other policies at the local level. So I just wanted to offer that as a hopeful counter to what I did totally agree with Professor Roman. I just wanted to be a little bit hopeful.
And our next question, what civil rights do migrant children have when arriving in this country? And how does the expulsion of these children tie into those rights?
I guess I'll start. I work at the U.S. Commission on Civil Rights, and I'm, not speaking in that capacity, but a couple of years ago, we had a public comment session in Washington, D.C., and we wish we could have gone to the border, but at any rate, a lot of folks came and testified, and we took a look at the civil rights issues happening at the border and analyzed the right to family unity in particular as a civil right. So that's one right that folks have. There's also the right to equal protection and the right to due process, and those rights belong to every person in the country. And so those are fundamental rights that are behind, some of the agreements to be treated well. Of course, there's, the right to bodily integrity, which is a fundamental human right as well too. So there's, in practice, not very many rights, but to answer the question, of course, every person, enjoys fundamental civil rights, whether or not they're coming to the border. And I think that the right to family unity, in conjunction with the right to equal protection, to not experience, racial discrimination in family unity, is something that should be, developed and litigated more and talked about more, because, this is just heartbreaking for Central American families, and something that was obviously targeted. And, we have, some original civil rights cases. The Loving case, for example, is based on the right to family unity, and also, the right to equal protection in that intersection. And that belongs, of course, to migrant children, of course.
If I may, I guess I'm going to be Dr. Doom here in terms of the Q&A. I guess I couldn't differ more in terms of what the federal government has done. When you look at family separation and the thousands of children that have been separated and attacked physically and sexually in a host of ways, and I'm not talking about theoretical constructs.
Oh, I'm sorry, can I just clarify? That we found that the federal government was in violation of those rights.
Okay.
It's a terrible policy.
If I may continue, and I'm sure you'll have a chance afterwards. This is something that's been going on for years in terms of these efforts, and we have a long history in the United States of not recognizing basic rights for undocumented workers and their children, and this administration in particular is among the most notorious and the darkest in terms of our dark times vis-a-vis immigrants. So I think it's important not to lose hope, as Professor Aldana raised and as Ms. Gonzalez was just alluding to in terms of efforts, but I think we need to be realists in terms of these times and the likely impact of anything will change absent an administration change in the federal government. And one of the things I'm doing in some of my current work is also looking at invoking international law in terms of war crimes and human rights violations against the undocumented, and particularly undocumented children, because I can't think of a time other than the Americanization movement of Native American children that we have treated innocent children worse.
I'm so sorry I interjected, Professor. I just wanted to say I couldn't agree with you more.
Do you all believe that immigration will continue if there's a change in administration?
I'll join you in the doomsday, Professor Roman. I mean, frankly, I think it's been really an interesting landscape in the last few decades when we compare and contrast President Trump's response with President Obama's response. I mean, I have to say, President Obama absolutely broke my heart. And I think he broke the hearts of so many of us who I think we gave him so much of the benefit of the doubt. So many people were saying he's just doing this in order to set us up for success. And then it dawned on me that somebody who does what he was doing just profoundly lacks empathy and fails to recognize the intersectional ways in which race in this country has to be discussed. And it was just heartbreaking, the numbers, the policies. And frankly, I don't think as a nation we're ready for more radical action. I mean, the people we chose to be our Democratic nominees, whether they were the safe choice because Trump or nothing, and we were afraid that selecting anyone more visionary was going to lead us to Trump, or whether it's a reflection of who we as a nation are, kind of still holding on to profound fear of being, dismantling the status quo because of what it might mean to our own sense of power and economic sustainability. I think that's the conversation that we need to have. I think I'm hoping and praying that Biden wins the election. I'll just be honest about that. I mean, what choice do we have? But do I think it will be a radical transformation of immigration policy? I do not.
Can you comment on ICE's deportation strategies, and do you envision that they will continue to deport immigrants at high rates to countries that have been found to be a hotbed for COVID-19?
I just want to say that in Guatemala, the COVID-19 pandemic started there from deportation. So I would, phrase the question almost in the opposite. The United States has been exporting a lot of disease to Guatemala, and that follows along a long history of medical experiments on Guatemalans, and not and kind of aligns with some of the politics of Guatemala as well, and the racial discrimination and the discrimination against indigenous people there. But the deportation, I think, has accelerated under COVID and in extremely cruel ways because COVID has been exported. And there's also, I'm sure Professor Aldana is familiar with this, but some folks not wanting to receive people coming back any longer because they feel that they want to protect themselves. And then we've seen Central American governments saying, with public campaigns saying, we need to welcome everyone. We need to stop discriminating against people just because they're a deportee. But I found that, very troubling that we're exporting, just like we've exported gangs, we've exported so many things to Guatemala. And so I do think that the deportations will continue. And I do hope that if we do change administrations, that these very hard questions are answered by the Democratic Party, who are also responsible for, the ongoing discrimination and underlying policies.
Yeah, if I could add one thing, I agree with the last statements, but I want to take issue with a little bit of the question in terms of historic rates or high rates. I have a few articles coming out this year if I could ever get law students to get back to school, and it's not their fault, of course, in terms of those efforts. But one of the projects I'm writing on takes to task the narrative that the bluster and the posturing of right-wing politicians, particularly Donald Trump, has led to the mass deportation and the deportations of millions of individuals. It has not. It's actually at rates smaller and significantly smaller than what President Obama did. But what has happened is, one, the silencing that I spoke to a little while ago, the fear-mongering externally that promotes violence, but also internally that keeps a community, a significantly important economic community, in a state of fear and isolation, particularly in light of the pandemic, but also provides an ongoing political release valve for political failures in terms of not individual failures, but individuals that are failures, like President Trump. And it allows him to basically grab that monopoly-like get out of jail free card in terms of the political fallback, to always blame the undocumented immigrants, the threat of the invasion, the armada, so to speak, coming in terms of that caravan, to use that repeatedly. And it's not only in the US, it's in Chile, it's in Brazil, it's in a host of countries, in Dominican Republic. Right-wing politicians use this card as a vehicle for their base to promote nationalism, to promote hatred, and the facts are otherwise. But what it will occur, what does occur, that is, excuse me, in terms of the failure, is that we don't have much change, be it Democrat or Republican. And for a change, would love to see that, fingers crossed and everything I can do for the sake of my 5 children, that we will have systematic change at least at the head, and then maybe the Latino and Latina communities will use their political power and might to force some issues, because I too, like Professor Aldana, was waiting for comprehensive immigration reform. And maybe I'm more sympathetic, but tough times, and both parties are to blame.
I want to thank you all for your very insightful commentary and, of course, your excellent presentations. Professor Iglesias?
Thank you very much, Leandra, for moderating the last panel, and for all of you for being with us through the conference, and for all of your expertise, and that includes the panels before you as well. Now, I wish, Susan, that your photograph, that beautiful photograph about the beauty, was on display right now as we're talking, because I think that that's a good way to end, in the sense that there is a lot of beauty, and these young people tend to have more hope than some of the older ones of us. And so I do want to not create a closed narrative of hopelessness. In fact, on the contrary, I want to invite all of you after all of this very, very hard work and intense legal analysis and political discussion, to a happy hour, a virtual happy hour, believe it or not. And we can socialize a bit. And the way that I'm hoping to structure this is a little bit experimental. So some of you may fall off, and others of you who hang on may have a really great opportunity to mingle and chat, because the structure of the program has had to be according to the webinar platform. And so many of you who I see as attendees, you haven't seen each other and you haven't seen yourself interacting with the speakers and the panelists. And this is going to be your opportunity. So our plan, what we're going to do is we're going to break you up into rooms, and we're inviting you to join us in those rooms by clicking on the link. If you go to the question and answer, you'll see the links. Sabrina Segura, who, by the way, we can all congratulate and thank for her help in the background with the communications and just managing the technology here in this conference. There's multiple links to the Zoom room. And if you click on it, we're going to find each other there, and you'll see each other now. The veil will lift and we'll be able to see each other. And then we're going to gather, and then we're going to go into separate rooms where you'll be able to talk to each other. And you'll do that for about 10, 15 minutes, and then we'll switch you into another room so you can talk to another group as if you were moving around the halls of AALS. And because I cannot resist the teacher in me, you have an assignment. And that is to introduce yourselves to each other and to talk about all the ways in which this conference has made you hopeful about law and the use of law to change our society. All right? So let's all click and meet in this new platform environment where we'll be able to see each other, and then we'll take it from there. And we'll see how many don't fall off of the wayside. But in any event, congratulations to everybody. Let's give ourselves a virtual hand, and I'll see you in the happy hour, hopefully.